think. And then here's Dean, and I will disappear.
There's Dean. Okay, so I think we have everybody, and it's after 5:30 if we want to start the pre-meeting. I don't know, Jim, if you want to start us off, or do you want me to give the background, or how do you want to do this? Oh, you're muted.
Trying to use the space bar. Why don't you start off, give everybody a summary of where we are?
Sure. Okay, so as you guys saw from my emails, basically at this meeting, we wanted to discuss procedures moving forward for the board. We had a lot of feedback from the public. We had a lot of feedback from you as the board members, and also the applicants too, in regards to our board procedures that we had presented to you a couple of weeks ago, which was basically tonight we were planning on holding a public hearing for a number of the items on our agenda, actually all 6 items on our agenda. And the way that we were going to go through that was we were accepting public comment for a week up until today. In regards to those items, we were going to have discussion on those items, open a public hearing, read all of the emails that had been received to date into the public record, close the public hearing, but leave the record open for an additional week for people to comment after seeing the live planning board meeting. The public and yourselves didn't think that was adequate enough, not enough transparency, et cetera, because there are quite a few big projects on our agenda this month. You know, multifamily housing project, the Vilas home, the Durkee Street projects, et cetera. So what we want to do is discuss our procedures going forward to, you know, maybe make this a little more transparent for the public, allow them to comment live during our Zoom feed, and what options we have to do so. So we put together a draft version of those temp board procedures. We sent those around to you earlier today. I don't know if you had a chance to look at those or not, but during the meeting, I'd like to maybe pull those up on the screen. We can go through together what the options are for the public in regards to participating at the meeting on the 27th. We are suggesting, and you know, I talked with Jim about this too, tonight not opening the public hearing for any of our agenda items, simply talking about our board procedures and tabling all of the items tonight until the 27th, when we have better procedures that allow the public to participate a little bit more. Go ahead, Kurt.
So, Milena, does that mean that the public comment letters that you received up until noon today won't be read tonight because the items that they would be read for would be tabled?
Exactly, yeah. So we would keep those. Shalice is keeping a running list of those, and we would read those on the 27th. So, I mean, in addition to allowing the public to now, you know, possibly speak live during our meeting, they would have another 3 weeks to also, you know, email us. And one of the other options that we have, I don't know if you saw or not in the temp board procedures, was to call and leave a voicemail. They could, you know, leave a video with us, email us a video, and then again, like I said, become live attendees at the meeting. And then also dial in as well. If you don't have internet, you know, that's you know, there's another option to be able to dial in with your phone and actually be an attendee, and it would just show your phone number there. And you could also participate in the same way as a regular attendee that video conferenced in. So I don't know, the only other item that we have on our agenda that I wanted to talk about in the pre-meeting too was our bylaws. The latest and greatest version you guys should have, which had been reviewed by Dean. I don't know that we can vote on those tonight because there has been some additional discussion in regards to the roles of alternates. And I think, you know, our bylaws are kind of lacking in addressing that. So I don't know if we want to just discuss the bylaws tonight and any changes, additions, edits that we want to make to those, and we'll put it back on the agenda on April 27th, and then we can have a vote at that time. Go ahead, Rick.
Going back to the first issue, how will we know that we've received all of the correspondence, the written correspondence?
There's an email that was posted with the notice for the meeting. I think it's cityinfo@cityofplattsburgh dot whatever. Shalice is actually getting all of those emails and she's compiling them into a list.
Okay, the only reason I ask, I received one that I didn't see through the email. And it was addressed to info. It was addressed to cityinfo@plattsburghcity.gov.
Yep, that's the one that everything from that email goes to Shalice. And if any of you as board members receive emails, forward them to Shalice and she can add them to the record.
Okay, this came as a hard copy, so it was
Okay.
delivered.
So on that, two interesting things here, Milena, that now I have questions about.
Mhm.
We receive emails to our personal accounts that I guess, how does somebody need to let us know that it's a public comment they want read publicly if it's not to the right address and it's coming to us?
Right. Shalice can probably address that. I believe that was outlined in the notice. I think there was a special subject heading they had to put in the email. Is that correct, Shalice?
And I guess we can, sorry, I didn't mean to interrupt Shalice. Go ahead, Shalice.
Nope. You're muted.
Sorry, I was not able to unmute there for a second. Yes, the public notice did state that the comments had to be emailed to cityinfo@cityofplattsburgh.com, I believe. They had to include in the subject line planning board comment 4/7/2020, or if it was a zoning board of appeals comment, then it was zoning board of appeals 4/6/2020. It had to include the name of the board, the date, and that it was a public comment. If they're emailing you guys directly, I guess maybe just respond and clarify whether they wanted it to be a public comment or just a communication to you.
Yeah, I don't really want to pass those. I mean, I like that idea, Shalice, to say, look, if you want this to be read as a public comment, email this address rather than us forwarding
Right.
them on as public comments when they may not actually be intended for public comments, or we could potentially vet them, which we shouldn't be allowed to do also.
No, that makes sense to confirm
People
whether or
use
not
the
they
right
want it to be on the public record.
Yeah, we need to, yeah, I would prefer to just direct people than be responsible for passing on.
Sure, I
How
agree with
is
that
this
as well.
information-
Go ahead, Loretta.
How is this information being disseminated to the public?
Shalice.
I'm sorry, I didn't hear the question.
How is this information being disseminated to the public?
The public notice was posted in the Press Republican like it normally is. It's usually about 5 days before the meeting. I typically put it in there the Wednesday preceding the meeting that has all the information about how to comment in there. I believe that information is also available on the city's website, on the planning board page and the zoning board of appeals page as well.
And I think this time around, because we had the temp board procedures in place, I believe we posted it on the Facebook page. I believe Ethan had done that as well, and the city's website on the main page.
Yeah, it was posted as a news flash. The way that we post the news flashes, it came up weird. It came up as a mayor's office news flash, but that was us posting it for the zoning and planning board. Zoning and planning boards, it was in the news flash section.
So we'll do that again when we update our board procedures. We'll make sure it's on the front page of the city's website, as well as the planning board and zoning boards pages on the website, Press Republican again, and the Facebook. So I know, this isn't the best timing, best case scenario for any of this, but, as we've discussed as a board and with the chairperson and, staff and the applicants, we can't stop having planning board meetings. And I think we all agree that we need to keep moving forward, moving these projects forward. We're not trying to rush anything at this time. I mean, we have next month we have an applicant that just simply wants to, replace his roof in the historic district. Are we going to make him wait until August to have to do that, not vote on anything? I don't think it's fair to any of our applicants to stop meetings at this point. So I think, we're doing the best that we can to satisfy, the public, the applicants, the board, moving forward with these procedures.
And just to chime in there, Milena, so there has been some comments submitted, very public comments, stating that the planning board and the zoning board should not be acting in any way, should not be meeting during the course of this pandemic. And the basis for those comments has frequently been Governor Cuomo's executive order. So I've been intimately involved with reviewing that order and analyzing it and applying it, and I flatly disagree with that. So that order states specifically, it's Executive Order 202.1, which was initiated in March 12th, early March. That order just states that a portion of the open meetings law is suspended with respect to in-person public participation. It does not in any way suspend any board meeting or municipal action. What has also been used is another portion of an executive order which says that there shall be no non-essential gatherings, which was also imposed by the governor. And that provision was tied to parties or social gatherings. There's no definition with that of what is essential or what is not essential. And there are certain definitions with that terminology. It's kind of new language now that we're using frequently, which talks about construction activities or, excuse me, sorry, my daughter was opening my door. Construction activities or employees. And so that's unfortunately being misused here. I've attended several meetings from NICOM and the Committee on Open Government. There are planning board meetings that are occurring throughout the state and zoning board meetings. And the requirement is that we need to follow the governor's executive order, which is what we're doing as far as live streaming, recording, creating a transcription. And more pointedly, in addition to that guidance, which everyone can receive from NICOM and from the Committee on Open Government, I had a very specific example just today where there was a complaint made to the New York State Attorney General stating that these meetings are non-essential and that the Attorney General should tamp down on the city of Plattsburgh and prevent these meetings from occurring. I responded to that accusation directly to the AG and actually had a phone conversation with the local AG who essentially agreed with my position, with our understanding that there is no prohibition on planning or zoning board meetings. It's just not precluded right now. So it's a false attack. And philosophically, some arguments are, some commenters are saying we need to wait until the pandemic is over before there can be any action. Obviously, we don't know when this is going to be over. Hopefully it's within a matter of weeks. It could be a matter of months. Just today, Governor Cuomo extended a lot of the provisions until the end of April. So it's really an unknown date moving forward. And with all the fact that there is no prohibition on these meetings, the fact that there's NICOM guidance, the fact there's a specific example from the Attorney General, it's just another thread that certain members of our community are pulling on to try to prevent any board action. As we see with these new temporary board procedures, if we can also enhance the public's participation telephonically or remotely, frankly, we're going to see that the meetings are just as efficient, possibly more efficient. There's just as much access. There's just as much participation as we could expect. And it's really the best we can do when it's fully legal under the situation that we're under.
Thanks, Dean. Jim.
Not sure whether we're raising our hand or not. I would wholly agree with both of your assessments. At this point, given the circumstances, I think, everybody has been trying to do their best to come up with a standard that we can implement as a board. And so long as this board can fairly and appropriately meet the guidelines of operation today, whether it's via state law, local law, ordinance, we we should try to continue on.
I'd like to comment regarding that as well. I did openly state that I would not vote until I've reached a comfort level where I knew that the public has given the input. We've heard it, we've understood it, and now we move forward. So I'm gonna stick with that. This is gonna be a moral issue for some of us as well. And, until we feel that level of comfort in the information that we've received, and that the information is complete and everyone's exhausted the opportunity to speak, then, I would not feel comfortable knowing that moving forward. So I'm going to watch it play out. You're doing a fantastic job right now. Everybody's given these opportunities. As I had mentioned earlier, I just want that mechanism that says when something's received, that we acknowledge that we've also looked at it, read it, and it's part of our understanding of the opposition or favoritism of any project. So I think we need to include that correspondence that's been received has been acknowledged by each of the board members moving forward. That's it.
And just a technical, I guess, question about that. If we feel that way, like Rick is saying, that we don't have enough information to vote, is it an abstention at that point instead of a no? I'm just a question on how that operates.
I don't know, Dean?
Yeah, I think hopefully that discussion would be made before it came to the actual time to vote. So when you say you don't need enough information, you don't have enough information. It's a question of from who? Is it from the applicant, from the city staff, from our expert reviews, from the public? It really depends on who you're asking. I don't believe the project has changed significantly or substantially. I can't recall since when. So I think the project is what it is at this point. So if there's a question now, it's about the project. It's certainly fair game to ask the applicant to fill in some detail about the project. If it's a question of expert review that you don't feel some portion was reviewed properly, then raise that question now. But I don't think it'd be fair to anyone if you waited until the time to vote and said, oh, I really just don't have enough information in general. I can't make up my mind.
I'd like to be clear on my point though, Dean. I'm not saying that I don't have enough information. I want to make certain that every voice is heard. That's my sole point.
Dean, you're muted.
Well, I can't steal them. I don't want to steal the microphone, but I can't. So the reason that we had the prior temporary procedures was because we were trying to work out the kinks. And since that time, really the touch point has been the ability for the public to participate during public hearings. Unfortunately, there's not much guidance in either statute or case laws to say what exactly is a public hearing, but there's some underlying concepts. It's basically a right for the public to be heard and the benefit to the board that you get from having heard from the public. So the first ramification was because it involved written comments and extension of written comments, and also that was initially deemed acceptable because we already had an in-person public hearing where we had a room of 20, 30 people making in-person comments. So the thought was by adjourning it in February and now keeping that open for additional written comments, that would be a full and fair opportunity. Since that, and that was about a week and a half ago, that was the kind of the current status of the procedures. Since that time, though, we've gotten some more guidance from NICOM. Just on Friday, they recognize that this is kind of an outstanding open question for some boards as we deal with these technical issues. So the suggestion through the additional guidance that we received on Friday was to say, really, boards, do your best. We have the technology available. Let's try to at least get a call-in feature, but preferably have a live chat feature, like the Zoom feature. So that all fits with the underlying goal of let's get as much public participation as we can, But also, that being said, we want to be efficient and smart about it. We're not going to just turn the mic over to the wild west of the internet and say, give it to us, but it's rather it should be regimented. We should have, just like we do in a meeting, a few minutes per speaker. If there's one representative, let them speak for a group. Let's not be vulgar or vile or accusatory to the board. Let's be respectful, but let's give them a fair opportunity. And that's the goal here. That's what we're trying to do.
Dean, that's an excellent explanation. Thank you. I appreciate that. That goes a long way.
I think some of the things for the board to consider in operating under this Zoom criteria is under some of our normal guidelines where people were in front of us, where we held public hearings. We would have the opportunity to hold the public hearing. We would close the public hearing. After that time, there might be further discussion between the board, but then there might be a vote. One of the considerations of the initial temporary measure was having the public hearing, closing the public hearing, but for the idea of allowing and making sure that we're taking a good hard look, foregoing any vote on that until the following meeting. That's something the board is going to have to consider now that we're considering these public comments on or public attendance in Zoom, whether we continue with that as the original temporary procedures outlined, or we go more back towards where the board would normally operate with someone at a meeting setting. It's just something for the board to consider.
Jim, are you saying after the emergency order is over, or are you saying during the emergency order?
I'm sorry, I'm saying during the emergency order while we're doing these Zoom meetings. Originally the temporary procedure was that we would have a public hearing, a possibility of the board considering closing the public hearing, but there would be no vote in that same meeting. And then the board would consider whether they would leave the option of public comment open for a period of time and would not consider a vote for the application until the next meeting. Now that is a little different than the way we would normally operate in our normal circumstances. But that's something for the board to decide on here, as we're discussing things. Does that still stay in play? And do we still operate that way, given the abilities for the public that we're starting to create now, for the abilities of the public to actually be able to speak during the time of meeting, which we weren't looking at before.
Right. So technically, on the 27th, the regularly scheduled planning board meeting, we would hear the project, open the public hearing, we could close the public hearing, and you guys could potentially vote on the 27th. Or, like Jim said, you could, close the public hearing, leave the record open for a week, and then vote in May. So you have either option. I mean, typically, I think, like Jim said, regular planning board meetings, you are able to vote on the same meeting that you have a public hearing. That's typically how it works. But with Zoom, do we want to do that, or do we want to wait for another month?
Now keep in mind, board, for the board to consider. I understand there's all different types of projects that, as long as we're under this order and where we're doing these Zoom meetings, there's all different types of projects. Some, controversial, some not. Do we want to hold? We have to hold all that to the same.
Could we do something like when we are trying to decide if we're ready to move to a vote on an item, to make a motion that we're deciding whether or not we're ready to vote, and that motion requires a supermajority to pass. It is a higher threshold than the actual passage of the action, right? So that if we are reviewing a project that is, a front porch renovation or a roofing project or windows or something, and there's been no opposition, then we'd be able to easily reach a supermajority that we're ready to vote, and we could then vote. And if we have a project before us that has opposition and people aren't comfortable, we have a higher threshold of moving to a vote and would then have to meet that before we actually take the vote. Can we decide that we want a higher threshold for a particular project?
Loretta?
It's sort of along the same lines. I've given this a lot of thought, and for private homeowner projects like a new roof, new windows, a porch, that's not a business that the public is involved in, or is not something that is happening on the city of Plattsburgh property. For me personally, I think that those are probably going to be proposals that we can reach a consensus on via Zoom. For projects that are going to impact the city in general, something like the DRI or Vilas, those are very large projects. I honestly think that there are so many pieces of those projects that no one knows what it's going to look like until the dust settles on how everyone's gotten through this pandemic. And for instance, what's the prime group's financial situation?
I just want to, I'm sorry to interrupt, Loretta. I just want to give you guys a 1-minute warning. We're at 6 o'clock for the regular meetings time.
I think, but the only thing that we need to worry about is public hearings. All the other votes that don't require public hearing, we don't have to keep it open for another week, right? So for a roof or windows, those don't require public hearing. So that's kind of a moot point, I think.
Just to caution everyone, when we start talking about higher standards for a particular project, or using this kind of the independent subjective opinion as what's a community-wide impact or what's a local impact, that you really run the risk of creating some legal liability for the city. Because not only are we trying to protect the public, but we also have to respect the applicant's rights. And I just want to be cautious about that kind of language. But I think I probably ran out the clock. Ethan, are we switching meetings?
No, the planning board
We're
did
just
not
keeping
want
this
to
one.
have 2 scheduled meetings.
Okay. So this is our regular meeting?
Correct.
Okay.
So I guess we just need to formalize it and have Jim call the meeting to order and roll call and all that good stuff.
So Dean, just to real quickly to summarize that a little bit. So what you're recommending is that the board obviously has the option to make different decisions, but really to be cautious and try to be as consistent as possible with regard to applicants and the public.
Yeah, that's the point of having a procedure, so that we have the procedure in place that applies to everyone, and then we apply it equally, and the projects can live or die based on their own merits, but that it wouldn't be a different standard for one versus another. It's a standard in the policy that I would be concerned about, and whatever the decision is, that's up to the board.
Are we able to keep talking now, or do we need to like mute or something for the start of the meeting? Like, is this discussion ongoing, I guess? Because I'd like to jump on.
I think we need to call the meeting to order first. Yeah.
Okay. Why don't we switch over from our pre-meeting to our regularly scheduled meeting? This is a regularly scheduled planning board meeting for Tuesday, April 7th. It is a special meeting that I called to replace the March planning board meeting, which we had to postpone due to our current situation. I'd like to thank everybody for attending and call the meeting to order. Moving on to, I guess, our agenda as outlined.
Just to chime in, Jim, I would suggest we do a roll call attendance just for the benefit of anyone who's listening on audio or receives a transcription of this. And just for the record, I note that this meeting is being held remotely via video conference pursuant to Governor Cuomo's Executive Order 202.1, which suspends certain in-person requirements of the Open Meetings Law. It is being live streamed on YouTube with a URL that was presented and available to the public. It is being recorded, and the transcript will be created for this meeting.
Thank you, Dean. Shalice, perhaps you can run the roll call for us.
Yes. Jim Abdullah,
Here.
Marissa Gilbert,
Here. Derek Rosenbaum,
Here.
Richard Perry,
Here.
Reg Carter,
Here.
Kurt Gervich,
Here.
Loretta Rietsma.
Here,
And also in attendance is Milena Tamer, the city planner, and Dean Schneller for council.
Okay, thank you, Shalice. I'm going to keep our agenda in order at the moment. We'll move on to item C, which is other business. We have item number 1 and item number 2, which is adoption of the planning board rules and regulations and discussion of the temporary board procedures. Milena, perhaps it's best to start maybe with an overall summary of what staff has been looking at.
Sure. So item number 1 on our agenda, the adoption of the planning board rules and regulations, are essentially the bylaws for the planning board. We've had a working copy of that since December. We were hoping to adopt those tonight. Staff has had the chance to review and edit. Legal counsel has had a chance to review and edit. We are at a really close final version of that document, but we would like to maybe have an open discussion tonight based on that final-ish version, get some more feedback from the board members. You know, we have heard from our alternates that they'd like some additional discussion in regards to the board, I guess, makeup. Right now we have a 5-member board with 2 alternates, and our, you know, ordinance, our code, et cetera, is not very clear on the roles of the alternates on the planning board. So, you know, we could open the discussion in regards to that. And also, I think, you know, maybe we need to add some more detail in regards to alternates roles into our bylaws. So I don't know if you want me to pull those up, share the screen so we can all look at that together and maybe open the discussion. Okay, give me 1 second. I'll try to pull those up.
While you do that, I apologize, everyone. I'm having internet connectivity issues, so I'm trying to make things work here. If I disappear for a second, I'm just trying to get a new Ethernet cord.
Where did you guys go? Okay. Can everybody see that?
Yes.
Yes.
Okay.
Just to clarify, are we talking the temporary rules or the permanent bylaws?
No, we're doing the bylaws first.
Okay, the screen I'm showing looks like it's the temporary ones.
It's not what shows on my screen. Sorry, guys.
That's what I see also, Milena.
What do you see on your screen?
I see this temporary board meeting procedures.
That's the same thing I see as well.
That's what I see. That's what YouTube sees.
Okay. I'm going to close everything on my computer that isn't that document, and that might make it easier. Okay, let's try that one more time. Everybody see it now?
That looks right.
Okay.
That's better.
Okay, so Shalice, I don't know if you want to take over here. I know you put a great deal of time into drafting these. If you want to walk us through, or if anybody has anything specific that they want to call out, or if you want to kind of just go through them section by section.
I'd prefer section by section.
Okay.
I think that's appropriate too.
Okay. Shalice, would you mind doing that?
Sure. I hope you don't mind controlling because I am working from my cell phone now. So
Okay,
if you can just scroll whenever needed.
I can.
So the format of this document is based off of actually the county rules and regulations for the county planning board. So that is the formatting that we've used. A lot of the language itself comes from the city code. So Article 1 is the formation and objectives. Section 1 just describes how the planning board was created. This again is language that's coming from the city code. And Section 2 describes what the objectives of the planning board or planning commission are. The city code actually defines us as a planning commission. Article 2, officers and memberships. This section will discuss what the membership of the board is. It's a 5-member board. We do have 2 alternate members that are able to serve in the absence or in case of the recusal of a regular member. But this section, I'm not going to read all of it, but this section does cover the criteria for that. The term of members is discussed here, when they'll be reappointed, how they're appointed, things along that nature.
I'm sorry, Shalice or Milena, if we have questions or comments, Shalice, do you want to go through the whole thing and then we can discuss, or do you want to discuss as you go through each section?
It's up to you guys. Either works for me.
I wouldn't, Kurt, I wouldn't mind if we raise any questions or anything at the, at the end of the presentation of the article.
Okay, perfect. I'll wait.
So real quickly, it'd be, Article 1 and Article 2. Most of those sections are somehow outlined within our zoning ordinance or city law or state law. Am I correct? Possibly.
Yes. Most of the language in here is coming from, or most of the, the information in here is coming from state law, federal, well, not federal law, state law, general city law, general municipal law, the city code. That's where the majority of this information comes from. Some of this is based on practice that we've had as a planning board, and some of this is based on input we've received in the past, because this was circulated amongst you guys back in late 2019. But the majority of this has come from existing statutes.
So for instance, Article 1 and Article 2, the planning board, we really don't have a lot of say or change in this. I mean, these are.
Yeah, there's some of this that will not be able to be changed by the planning board. It's from the city code. It's something that we cannot change. And when I say we, I mean you guys, the planning board.
Though if there are things here that are dependent on the city code, we may push resolutions that ask the city code to consider a revision.
I believe the planning board is able to do that.
Kurt, I believe that's correct also.
Okay. I'll save my points until Shalice is done with the presentation.
Sure. Thank you. Section 3 discusses the chairman, how chairman rules. I'm sorry, I'm trying to follow along here. Section 4 talks about how the vice chair will be elected annually. Right now, this is one of those cases where there's an absence of any kind of definition for this. So right now, the vice chair will be elected annually. I believe that language was pulled from somewhere. I don't recall where at this point, but I don't believe it was a statutory thing. The city planner shall, in the absence of the chairperson and vice chairperson, perform the duties and responsibilities of the chairperson, except that the city planner shall never vote on any matter. Applications, hearings, and decisions. So this section will just talk about, how meetings are held, how they're announced, who can call a meeting. I believe that's the chairman of the board. Again, this is some language that's just coming from the city code and or some other statutory language. Meetings are held open to the public. Section 4, a member may participate in a meeting by means of video conferencing or similar communications equipment. So this is actually from open meetings law. Open meetings law allows and provides for video conferencing and part of meetings. So some of this language is coming from there, or is based off of those provisions. The planning board chairperson is the person to call a special meeting of the planning board. or as requested by a quorum of the members of the board. Section 6, the parliamentary procedure, I believe that's just something that was pulled from the county planning board rules and regulations document. Section 7, applicants or their duly authorized representative are required to attend any meeting. That is based more off of precedent and discussion with the board. In the past, the board has decided that any applicants before the board have to be in attendance, or they have to have a representative in attendance for them. Section 8, the option to vote by ballot or roll call shall be at the discretion of the presiding chairperson. I know Marissa in the past has raised some interest in voting by ballot, so we've included some language in there to allow us to do that. It also discusses how that will be done if video conferencing is utilized. Article 4, order of business. This is just the general order of an agenda, call to order, roll call, determine if we have a quorum, any staff reports, so any new information from Elena, and then we'll review any business before the board. Business may be reordered when deemed necessary or appropriate by the planning board chair. There's been a few occasions where I think certain actions required an approval that needed to be reordered in order to make sure that it was legally correct. Article 5, a quorum. I believe this is pulled partially from the city code and partially from state law. I apologize if I don't have that fully correct at this time. So for our board being a 5-member board, a quorum would be 3 members. I believe that section also included a statement unless a higher vote is required under some other rules or regulations or state law. So in the instance of a county planning board decision where it requires a majority plus 1 vote to override a county decision, that is where we would need a quorum, which is 3 plus 1 would be a 4 votes in order to override a county decision under law. Article 6, minutes. This is just general information. Article 7, attendance. So this one, we included some language here. I think this was just to cover general attendance things in here. It also addresses how alternates are to be used in the event of an absence of a regular member, or in the absence of or in the instance of a recusal by a regular member. So the general idea there is if a regular member is recusing themselves, they're not able to vote on an item, the alternate that sits for the first vote of the item, the first action of the item, they will be the returning alternate for any subsequent hearings of that item. In the case of an absence by a regular member. So for example, let's say Marissa was unable to make a meeting, an alternate would sit. Whoever is appointed, the chairperson is the person to appoint the alternate to sit in that absence. When Marissa returns the next month, if there is another hearing of that item the next month, Marissa is able to resume her seat because she is not recusing herself on that item. She was just absent. I believe there is some language in there, something that Rick had suggested in the past, that a statement shall be made and entered into the record that that member has reviewed all necessary materials. So they have, reviewed the minutes, they've reviewed the video, they've reviewed the discussion of that item. Article 8, committees. I think this was pulled from the county template as well. Article 9, correspondence and communications. It shall be the duty of the chairperson to approve all correspondence necessary for execution of the duties and functions of the planning commission. This is something that Jim's a little more familiar with, and to an extent Marissa has been familiar with as well. On occasion, they have to sign off on certain documents or communications going out regarding approvals or some other information. City planner may also conduct correspondence under the direction and approval of the chairperson. Article 10, changes in rules and regulations. This section just discusses how the board or commission may adopt or amend any information here. I believe it says a 2/3 vote of the board. So I think in this case, that would mean 4 out of 5 votes. And I believe that is all that is left of the document.
Yep.
Okay. I will open up to comments by the board. But I'll save it for the board if you have any comments or questions.
I have some comments. Of course, since I can't scroll back up, since I don't have control of the screen.
Where do you want me to go, Marissa?
Way back up, I think it would be Article 2, because you have a thing about a quorum there, and then you have a thing about a quorum somewhere else. So our first article is just, you know, blah, blah. Okay. See if you can find it. It's the third part of the second, perhaps. A short section about quorums. So you're mentioning quorums in 2 different places. So I'm wondering.
There was an entire article on quorums, I believe.
There's one.
Oh, there it
earlier
is. Article 4, 5, or 6, I think.
But at the bottom of section 2, the last sentence is a quorum shall consist of a majority of the whole planning commission.
The entire planning commission is a 5-member commission.
I think that needs to be very clear, because later on you mention, when you say the whole commission, it's the whole regular commission. The word regular, whatever, needs to be in there every single time if you're talking about the 5, because if you just use the entire board or the whole commission, it's going to be 7. Uh-oh, my voice is already starting to go.
Yep, and there's another point, Marissa, that it refers to the entire planning commission, which is yet another confusing term. I would suggest, I mean, I have a larger suggestion about eliminating alternates and moving to a separate board, but I hear your point. I would remove the terms whole and entire and full as modifiers of planning commission. If the intention is to talk about the 5 voting members, I would say 5 voting members. If the intention is to talk about 7, I would make that text read voting and alternates.
Yes, I agree on that. Some clarity. It's a little bit back and forth. And then a couple of times we have the word planning board in the document instead of planning commission. So I think we need to be consistent with that and pull out the word board.
Sure. I believe the Article 5 quorum section that is currently up on the screen, I believe that exact language is pulled from the code. So I don't think this is something that we are able to alter.
We could add additional definition of what entire membership means, perhaps at the end, or okay.
So while we're also in section 2 reads, the mayor shall appoint a chairperson of the planning commission from among the regular members, which is very different than how we select our chairperson now. Currently, we select and vote on a chairperson. A board, the mayor does not appoint that chairperson. And so that is a significant change.
This is another section that I believe is adapted exactly from the code.
Yeah, and Kurt, sorry, Shalice, just to chime in, this is something that's been on my to-do list. There is actually an inconsistency in the code where it talks about this language appears in the code, but there's other, I can't recall exactly offhand, but there's other language talking about that the board shall annually elect its chairperson. So we've identified that inconsistency. To resolve it, we went back to state statute, and that more closely mirrors the provision saying that the mayor shall appoint. So that is something on my list that I need to do by local law to recommend to the council, or well, they can adopt it themselves, but it's something that needs to be cleaned up. But what's shown in section 2 mirrors what the state statute shows. So that was the preferred route.
So I have a question, Dean. A minute ago, you said it more closely mirrors the state, and then you just in a statement said it mirrors the state. And I'm curious to know if it mirrors the state and if we are required to do that, or if we can not chair and vote within the board if the state gives space for that.
I can't say without pulling the state statute to say it's verbatim word for word. But this is a, it's an issue that we've identified as far as that inconsistency. And then so we looked to the state statute, and this was the paradigm that the state had in their general city law as far as mayor selecting. So whether there's room for maneuvering, either way, the council is going to have to clean this up one way or the other through a local law. And likely they're going to want to mirror what the state statute says, but it would be a council action to clean up the local laws.
So I guess I want to know if we are required to follow, if I want to know what the state statute says, and I want to know if we are required to have the chairperson appointed by the mayor, or if there is a provision that does allow the board to select and vote on our chairperson.
So I can double check that, but in general, there's a concept of preemption where if the state is in an arena where they've regulated it or adopted legislation on it, the local municipalities have to conform with the state's guidance. But I want to fine tune that myself because I don't want to have that question either.
Okay, thanks, Dean.
And I agree with that. I need to see the actual state law to see that this must happen this way.
Before we have any more comments or questions, Shalise, are you capturing all of these comments and edits that are proposed?
Yes.
Okay, good, thank you. So I'm trying to do it too, and I just wanted to make sure that somebody was doing it.
Yeah.
Thank you.
One of the other things that I had seen, I was interested in when we talk about back to alternates and how alternates are picked, and the two scenarios where you've got a recusal and you look back and you say who has attended most of these and basically heard the evidence and can step in better. And then the other wording is who's got the most time. So I'm thinking if that's the case, there should be an ongoing list in your office that is always tracking of the alternates, who has the most time and who is going to be the person to step in. So it's an easily consulted list, not a discussion.
I'm sorry, when you say who has the most time, are you saying who's served on the board the longest or who's been present at the meetings a lot more? Or
that's what I'm questioning. For instance, say someone's been on the board, but they've been on the board longer, but have not actually attended meetings for whatever reason. While the other person has been on the board a shorter calendar time, but has actually attended more meetings. I can see that actually happening. So I'm wondering what this wording really means about who's going to be stepping in the alternates, how that is actually the greatest amount of recent consecutive time served. Well, if you served, but you didn't actually go to the meetings, you didn't really serve.
Sure. So there was two different comments that came into play on the wording of this. One member commented that they wanted the person that had essentially served on the board the longest to be the first alternate. The other person commented that they did not want anybody who had, for example, served on the board 20 years ago for 5 years, and then they took a 20-year break, and now they're back on the board for 1 year. So they have cumulatively 6 years. And we have somebody who's been on the board more recently for 2 years. They would want the person that had been on the board more recently for 2 years, the person with most recent consecutive time served, to be the person that would serve in that instance. So that's how the wording ended up like that. The served time, at least in those discussions, was intended to mean from appointment, from most recent appointment. I don't mean most recent reappointment date, but the most recent date of appointment for their term that they've been serving, whether they've renewed that term or not.
So what happens essentially is the poor second person who was appointed later pretty much doesn't get a whole lot of experience sitting at the table because they're always the last alternate to be picked. And so we aren't alternating our alternates.
There, So Milena passed me last week a document from the American Planning Association about alternates and how they can be used and are used, and some of the kind of criticisms that come up surrounding alternates or the complexity of alternates. And there are some suggestions about how to resolve this issue in that document. And I would maybe, Milena, that you want to send it to everyone
Sure.
for ideas about how to clarify this point. One suggestion that the American Planning Association, that when it's time, when somebody has to recuse themselves or when they are absent, that you would flip a coin to determine which alternate sits. Or you would have a rotation that would eliminate that problem of the second alternate always just having to sit and never getting any experience. Or you would go straight by seniority, and that would eliminate any confusion. But the way that this is worded right now, I see two different criteria that could be confusing. There's this recent and consecutive time thing that makes it difficult. And then there's also attendance upon an initial vote. But sometimes, we hear items many times before a vote. And so conceivably you could hear an item 4 or 5 times over a period of months with no vote. And then there is a vote taken where the person who has not been hearing the item is the one there and steps in, but they don't have experience on that item. And so, there are conflicting criteria here that need to be resolved. So we just have one criteria for determining when alternates sit and who it is.
And so go ahead, Jim.
Yeah, up until this point, my experience on the board, alternates and how we handle alternates and even how we handle chair and vice chair. Seniority, in my mind, has been how the board has handled that in the past. With that said, the alternate component wasn't really dealt with because we're a 7-member board not so long ago, and I don't know that we always had a full 9 members, 2 alternates. So I really do think we need to think about this now that we have a 5-member board. We have, showing regularly, and I would anticipate this will continue to occur. Does that occur with seniority? My personal opinion is that rotation is a better idea to allow for true involvement. In addition to that, I think we also need to consider how we handle alternate involvement. Although a voting member, do alternates sit and are they allowed to ask questions of the applicant like a normal board, and they just aren't allowed to vote? Those are things that we should consider and make sure are clear in our outline.
That was going to be my question, Jim. Is anything in here explain that when an alternate's at a meeting, are they a non-voting member of the board sitting at the table, or are they just another member of the public? And I guess, where are they and what is their responsibility as an alternate?
Dean, I don't know if you're able to clarify this for us. The only thing I've seen on that floor was out of New Hampshire. I don't know how that compares to our own state's laws, but it indicated that alternate members, they can sit at the table, but they're not meant to be included in deliberation of a project when they're not needed. That was guidance out of New Hampshire. I don't know how that applies to us.
So again, we'd have to parse out the word deliberation. In general, I don't think it hurts having as much participation and input as possible. That's always a good thing. So to say they're a member of the public, I would think that would be a kind of a attack on their status. But when you get to the level of deliberation, I think a good analogy is a jury trial. If you have a jury trial, you'll have 6 or 12 members selected as jurors, and then you'll have 1 or 2 alternate jurors. Those alternate jurors sit and observe throughout the whole trial proceedings. And at the close of evidence, when the case is done, just before they go back into jury deliberations, that alternate juror is frequently excused and can't participate any further. So in this case, the analogy would be if the alternates are there, right now my position or my advice has been with the permission or at the discretion of the chair, they can allow the alternate to ask those questions. And if you want to memorialize it, that's fine. But when it gets to the point of motion for approval or disapproval or whatever on the specific item, at that point, the alternates loses their voice because that would be participating in deliberations when it's on the table for them to decide.
So as I joined the board in 2012, I'm the longest serving member along with Jim. We right about the same time and can't remember who was appointed to the board first, but and I've been both a voting member of the board and am now the most senior member of the board and an alternate. And I don't exactly know how that happened, but okay, here we are. And so sitting in both positions, I believe that, number one, we should draw, as Dean said, right, we should invite participation as much as possible, and we should draw on the resources of our alternate members who study the same materials that the voting members study. They spend the same time studying those materials. They attend trainings like voting members, and to not allow them to deliberate and engage with applicants and ask questions and discuss with the board seems like we would be missing an opportunity to hear from people that have spent a lot of time studying and thinking about these issues. It also creates a problem if you're going to not give the alternate voice. It creates a problem where the alternate then is their only outlet for a voice in public discussion is to use the public hearing comment platform of the general public, not the right avenue for an alternate to give their input. That hearing platform is there for the public, and alternates have a different platform in which they should be able to be heard. So if you don't allow them to go through the public and you don't allow them to engage with the board and applicants, then alternates essentially have no voice. And so while I'm actually in favor and would like to talk about eliminating alternate status into a 7-member voting board is a different piece altogether, I think that Dean's suggestion of including alternates in discussion and consideration up until take a vote would be the way to go.
I just want to clear that point. I was using the term of art deliberation, meaning analogous to the jury trial, that when they deliberate after hearing all the evidence. So my position was discussion is appropriate, but once the item is moved to the table, at that point, the mic would be taken away.
I appreciate your distinction of the legal ease, Dean.
I would like to also chime in here. I used to work for the town of Plattsburgh, and they were, I believe, a 5-member board with 2 alternates as well. And they did allow the alternates to speak during discussion, ask questions of the applicants, etc. So they were involved throughout the whole process because, of course, they're expected to be just as knowledgeable as a regular board member in the case that there is a recusal or there is an absence. So I agree that I think it's important if alternates are part of the discussion throughout the project review. But again, obviously, unless they're a sitting board member, they wouldn't have a vote.
So honestly, unless I'm hearing concerns with the rest of the board or questions about that, I would think I'm in favor of staff exploring language that goes in that direction. That allows for, once again, alternate involvement right up to the point where, legally they should stop due to they don't have a voting right, basically, unless there's something else that tells us that.
So my question for you guys then, we're looking at Article 7 right now, Section 1, which is 3 paragraphs long. So these 2 paragraphs here where the highlights are in yellow on the screen, you guys want to remove these 2 paragraphs and replace them with something else. Is that correct? I just want to make sure I'm getting it. And I'm, this is fine, whatever you guys want. I just want to make sure.
And
I'm
it sounded like
supporting
that, it sounded like that's something else per Jim and Kurt's comment was some kind of rotational basis, not a more objective, potentially random, but a more objective system that would allow rotation, either, I don't say flipping a coin, but maybe just a straight A then B kind of scenario.
I agree with that.
I do as well.
So
I do
I mean, I'm happy to put together whatever you guys want. I just want to know what it is you guys want. So on this, is that what you guys are looking for? An actual, you know, this person goes and then the next person goes and it's 100% alternated every time? No flip of the coin, no other type of procedure? Is that what we're looking for?
I think that makes sense, being rotational, but I think we need to leave the language that if an alternate sits on an item, it wouldn't be the other alternate next time that would sit on that same item. I think if they sit, then they need to continue to sit for that item until there's a vote.
So there's a difference here between kind of move ahead and how we deal with what we have already, what is kind of on our docket and in process.
I'd also like to throw in, and maybe it's in here and I missed it. I read it earlier, but the mayor appoints members of the planning board. If someone, I have not seen anything in the language that says if one of the 5 members rotates off the board for whatever reason, an alternate is automatically moved into that position. Is that how it's supposed to be? Is there any language that identifies, or if you're an alternate, that's what you always are? And if there's a vacancy among the 5, then the mayor will appoint someone to that 5 group.
Loretta, that's my understanding. When you're appointed as an alternate, that characterization sticks with you during your term. Obviously, you can then sit in during specific meetings if a regular member is not in attendance, but you don't automatically become an alternate to a regular member based on a permanent absence or a resignation by a regular member. That's a specific term of appointment that you are either an alternate for set years or a regular member for set years.
But if a position became open on the regular board, the alternate would have the opportunity to, you know, express interest in that position, correct?
100%, and that would be the logical person next up. You would think it would kind of be like a baseball farm system where you bring people up from the minors. No offense, Kurt, you're not in the minor league, but I don't want to use that as an attack on anyone. But that you would kind of work your way through the system, and so, but it would be a mayor appointment / council approval scenario.
So do we want language that would make it incumbent upon an alternate to go through some kind of a process to be considered for a vacancy, or is that something that
I think it's already there because the code talks about the mayor shall appoint a regular member, the mayor shall appoint, with approval of the council, the composition of the board. I don't think it's necessary for this rules of procedure.
So as a board, I think that we would want to protect the experience that we are building and see our alternate members be promoted, for lack of better term, because something that we want to give both to our applicants, to the public, is consistency and experience and integrity that the board is building knowledge towards a particular, the way that it implements the city's plans. And it seems like we would want to strengthen that in some way.
I'm not opposed to some kind of aspirational language. I just was kind of trying to make the point that it remains the mayor's prerogative to make that appointment. So they're not bound by this recommendation, but certainly it makes sense. And I think it's logical that you would want to increase the experience as you go.
There is language in the city code, I don't know if it's in our draft bylaws here that speak to, the mayor should attempt to appoint members from all wards. And so that's kind of aspirational language like that. It doesn't require the mayor to do that. The mayor actually can't do that. We only have a 5-member board and we've got 6 wards. But the mayor should attempt to do it. So that's kind of aspirational. So maybe there's a little bit of a model for that. This is, while we're on the subject, one of the reasons that I'm interested in seeing how people feel about moving to a 7-member board is that the mayor is supposed to attempt to appoint members from all wards. Currently can't do that. We're only a 5-member board. So one board is perpetually, may not be the same ward. One ward is perpetually without representation. And currently, I believe that our board is entirely not representing wards 1, 2, and 3. I think that we are all currently from 4, 5.
I think there's one from 3, but I'm not, I don't
Okay,
have that.
I don't know where everybody
right
lives. It was just a.
But you're right. We do have at least 1, if not 2 wards that are unrepresented right now. I don't have that in front of me.
So I understand that this decision about moving to a 7-person board and and all is not one that we can make. And so I am okay with discussion on the bylaws and passage of the bylaws, because we do need bylaws. And then on a parallel track to discuss a resolution of the planning board that would encourage the council to consider a 7-person board so that we can represent all wards.
I think, Kurt, to your point, we should probably do a little bit of research. I'm not 100% clear on, reasoning and why we did it, but we should research why the planning board and the zoning board went from a 7-member board to a 5-member board in the first place, and then, look at our recommendation again.
Totally different. It's a parallel conversation or a different conversation. I don't want to sidetrack the discussion of these bylaws, except to make that point that we do have some aspirational language about the mayor in here. And so we could include some language like that about alternate members moving to the voting board.
Okay, and just to clarify one of our last items about the appointment of the chair and appointment of members by Common Council. I'm assuming, Dean, you will review our zoning ordinance and state law and confirm, that we have clean language that addresses both the zoning board and the planning board.
Yeah, that's certainly the goal. And as everyone is aware, I don't know if I've copied the entire board on this, but this Milena may have given an update. The city has received a grant and is currently in the process of contracting with a consultant to revamp our zoning code, to update and solidify and finalize our LWRP, our local waterfront revitalization plan, and also update and modernize our comprehensive plan. So some of the, I hate to, no excuses, we want to have consistency, but because we have these consultants in this this process in the works that's going to basically revamp our entire code, hopefully we would accomplish all those goals at that time rather than trying to piecemeal it.
And just to give an update, since we got on that subject, we recently signed the contract with Saratoga Associates. We're hoping to have a kickoff meeting, unfortunately, probably with Zoom, probably in the next month or so. After that, they would start drafting goals, vision statements, etc. And then, next step would be a public meeting to get feedback from the public. So we are moving forward with that. We're hoping in the next month or two to have a kickoff meeting.
Can I go back 2 subject matters? When the city changed from a 7-member board to a 5-member board, I'll tap into some of my historic knowledge, and Marissa, you can chime in on this as well. With the 7-member board, the majority would be for positive votes. Many cases, you would only have 5 members of the board that were seated, leaving the applicant at a disadvantage because they still had to receive 4 positive votes for an application to be approved, which was a supermajority at that point of the present members. So rather than have the applicant be at a disadvantage, what the city opted to do was change the structure of the board, that if 5 members were a consistent number, only 3 positive votes would be required for an application to be approved. That was the logic, as I remember, behind the change from 7 to 5.
What I recall is New York had changed some of the laws for towns and cities, whatever, allowing the smaller boards because we had attendance problems. You'd have 7 people on the board and 2 people in Florida, no alternates. And as he said, you'd have 5 sitting, and then that's unfair to the applicant. So dropping it down to a 5-member with 2 alternates, still 7 bodies. New York as a whole recognized it worked, and New York as a whole had recognized that there was a problem with getting board members to volunteer and consistently show up.
So, contribute here, I guess, if we're going to discuss it. You know, 4 out of 7 is a smaller percentage than 3 out of 5. And so in terms of a quorum, getting 4 out of 7 should be easier to do. They're very close. Statistically, slightly easier. Our bylaws also currently state will allow video conferencing, which totally changes the dynamic of being able to attend meetings or not. If we're going to allow video conferencing, then our numbers of absences should reduce. And also, if we're going to allow video conferencing, then we are further reducing the need for alternates at all. And we will get to a point where if people are video conferencing in for meetings and we're counting that as attendance, then an alternate's opportunity to participate is very, very slim. So either I think we will get ourselves into a place where we have difficulty getting people to be alternates on the board, or get to a place where it just makes more sense to have a 7-person board anyway. Those alternates are spending the time there, and now they're just not getting a vote. So I think you either allow video conferencing and then eliminate the alternate status and go to a 7 board, or you don't allow video conferencing. So that your alternates are still serving some value.
So Kurt, would it be, at this point, would it generally be fair to say that we focus on cleaning up these regulations as a 5-member board, which the council has at this point, get it cleaned up as a 5-member board so that we, have clear rules for all the things we've discussed here. And then in a parallel track with maybe our zoning ordinance rewrite, maybe that takes a longer time to reconsider whether we go back to a 7-member board.
Yeah, that's my suggestion, and it's clearly not our decision. We can pass a resolution that says we recommend it, and the council may or may not modify the code for us. So yes, that is my recommendation. But as we are moving towards that, there are some places in these bylaws that it then does require some clarification. For example, in Article 5 about quorum, Section 1 reads, for the transaction of ordinary business, a majority of the commission, at least 3 members, constitute a quorum. As a 5-member board, that's correct. The next sentence says, a majority vote of the entire membership shall be necessary for the adoption of any matter. Entire membership is very confusing language. To me, entire membership is 7. We are a 7-person board with 2 non-voting alternates, but we are entire 7, which would require 4 to adopt any kind of resolution or policy. Or
I think Marissa and Kurt, your comments are valid, that we need further clarity whenever we use the word membership to really define it and make it consistent. So that's a good point and valid.
I actually have one other point, and it's regarding the different wards of the city being represented. You know, especially considering some of the larger projects that we now have on our plate, it does seem important that we have a more widespread representation on the board. And I'm not sure how much we can codify that or, you know, mandate that, but, you know, Reg lives across the street from me. I mean, we clearly, our voice is the voice that comes from Cumberland Avenue, and that's, you know, that's 2 people. There's a lot of the city that doesn't have a voice at the table, and I don't know that any opportunity is created for people to even express an interest in having a voice on the board. And so I don't know if there's a way to, or maybe there is something somewhere else about how the mayor goes about identifying people to serve on the planning board. You know, might there be an opportunity where if there is a vacancy, people in a ward where that vacancy occurred can be given a heads up, and if they have an interest, at least make that known. Because it seems like the appointment process is pretty arbitrary.
We could always ask the mayor to reach out to the counselor that represents that ward from Common Council and start an application process that way.
I believe that the zoning board in their bylaws or in the city code, I don't know which, has a stipulation that no 2 voting members can come from the same ward. Am I correct on that, Dean?
I'd have to research. I can't quote it offhand, so
Sure.
I'll check on that. But yeah.
I know there is a procedural step, and Marissa, if you can weigh in maybe to clarify this, I believe the zoning board does have members recuse themselves if they're having a hearing of an item that's from within their own ward or within 500 feet maybe of their.
They use the same 500-foot circle drawer that we do for area variances. So in other words, whoever gets a notice, if you get the notice, you're within 500 feet or touching or whatever the rule is, you recuse yourself. The end.
Sure. Do you know what the history on that procedure was?
So we thought it was a really good idea, that it prevented cloudy issues. If you just stepped away, you weren't trying to say, I don't have any issue with this. This is not interfering with me, even though it's within 500 feet. You just stepped away and didn't vote.
Okay, because I thought the intent of having somebody from each ward was to have representation, people who knew that neighborhood there.
I'm talking about the 500-foot recusal at this point. I'm not talking about no 2 members from the same ward. I don't recall that as part of our.
So I just,
bylaws.
sorry to cut you off, Marissa. I just pulled the code. It's 36054, and this is a ZBA, and it highlights that language that Kurt just cited. It's in your chat feature. If you guys can see that on the right of your screens. Can anyone see that?
Yeah.
Okay, so that's the language, which it does say the same aspirational language. The mayor shall attempt to appoint 1 from each ward, but in no event shall 2 members be appointed from the same ward. Again, for the ZBA.
Thanks, Dean.
I was just gonna say, I think that the issue, like Rick said and Marissa talked about, that in the recent past, I mean, boards have been down for years, I mean, memberships have been declining. So a lot of these things came about because of that. So we've put, you know, these things have been put in place because there weren't enough members no matter what. So you just tried to get whoever you could get. It just seems like now we're in a spot where we've actually got good attendance and we've got alternates that show up. So I don't know, I guess I'm just saying that I think that's why a lot of these things have come up, and that's why they've been put in place, because we may get to that point again, and at various points throughout the year, we could have 3 or 4 people show up versus 7. So
yeah, I guess my point is whether or not those people show up as alternates or as voting members doesn't matter. They are or they're not showing up. It's and so it doesn't change much to have our alternates just be voting members. But we can leave this for another conversation because we don't want to derail it. A question I do have is on Article 10, changes in rules and regulations. So this is another point. I'm just trying to raise the points where our definitions of quorum is unclear and how we're using alternates is unclear in these bylaws. So the first statement, the rules may be adopted or amended by the affirmative vote of not less than 2/3 of the full planning commission regular membership. So 2/3 makes it a super majority to change the bylaws. Although I do have a question here. It seems like there is some space where, number one, changes that affect the way alternates participate can be made without vote from the alternates. And that seems like we would want alternates involved in voting on procedural decisions that they also have to adhere to. It also means that at a meeting, you could have 3 regular members plus 2 alternates sitting, changing the procedures for the entire board. And that seems contrary to the intent. And so I think that the change in bylaws should require even a higher bar for change, include at least 1 alternate. So you'd want to go to, I don't know if that means 6 out of 7 or what, but this doesn't seem quite right in terms of process to me. And I don't have a resolution, but we need to think about it, I think.
Dean, can you clarify whether in any instance, if we have a 5-member board, are 6 or 7 people allowed to vote on an action?
Nothing comes to mind as far as precedent for that. But I appreciate the same comment that has been made before, that there needs to be abundantly clear who's voting and when and what everyone's status is. So that I think that point is valid. Again, I don't recall any scenario though where alternates have voted, but yep.
Okay, so if nobody else on the board has any comment, just to summarize, speak up if anybody disagrees, but we would consider these rules and regulations as a 5-member board, as we are today, authorized by the council. This cleaned up, hopefully over the next month or so. Board members can offer any other comments they have individually back to planning staff as they work through these verbiage changes and clean things up. And maybe at the next board meeting, rules and regulations that we may consider to adopt.
Sure.
Jim, you kind of broke up a little bit and I couldn't hear some of it. And I wasn't sure if you were suggesting that we are agreeing to live by these rules and regulations for the moment, or if you were just saying until the next meeting and then again and potentially adopt them then.
So I'm looking at, cleaning up these rules and regulations and getting them in place as the board as we are today, a 5-member board. If the board wants to consider recommending or moving forward to studying becoming a 7-member board, we do that on a separate path. You know what I mean? That if that occurs, down the road, then we revise these regulations to fit that if the Common Council moves that in that direction.
Yeah, I agree with that, but I just couldn't tell what you're motion on these bylaws right now.
No,
No,
Okay, that's what I couldn't quite tell.
no,
No.
staff will edit the document based on comments tonight. We will circulate that to everybody for review and any additional comments. And then hopefully we can have Dean review them as well again for a final time. And we'll get those to you and add it to the agenda for the April 27th meeting.
I was going to say I'm very happy that the board was able to sit down and really discuss these regulations item by item. It's something we've been, for lack of better terms, kicking down the road. And I would really like to have these in place. So if we can get them adjusted and the board looks at them favorably, we can consider them at our next meeting.
I agree, Jim. I think it will bring a lot of clarity that we have needed.
Okay, I'm going to stop sharing the screen now.
Okay, thank you. Thank you everyone for that. I guess, Milena, you were still, I guess, reviewing these two items, and we're moving on to item number 2, which is discussion of temporary board procedures.
Okay, let me pull that one up. Okay, can everybody see the screen?
I can.
Okay. So, as you all know, we had adopted these temporary board procedures based on the current state of emergency. These were supposed to basically outline the procedures for the board to operate virtually. Originally, our meeting tonight was to go through our agenda. We had 6 items on our agenda, all required a public hearing. Tonight was simply to hold those public hearings, potentially close the public hearings or adjourn them or keep the record open. It was up to the board, but we were going to hear the 6 items on our agenda for public hearing. But we had a lot of feedback from the public. They didn't feel like they were involved with the process. The city wasn't being transparent. They weren't allowing the public to speak and participate. So we put together a new draft temporary board meeting procedures document for discussion tonight with the board to increase participation from the public. And so I don't know if you guys want to go through this document similarly the way we just went through the bylaws, section by section and open discussion.
Just to chime in real briefly, Milena, thank you for that summary. We had a special meeting of the ZBA last evening that I was serving as counsel for. During that meeting, it was a very similar situation as you're confronted with tonight. The ZBA ended up adjourning or tabling all of the items on the agenda and then instructing staff to continue to work out these procedures to increase or enhance the public's participation through Zoom and telephonically and everything else. And also the ZBA designated their chair and Ms. Inslee, their quasi vice chair, to kind of serve as a representative of the board, so that after the procedures were discussed amongst the board, direction was provided to staff, then the staff is going to work with Ron and Kathleen to discuss the items they were going to bring to the board. But the bigger goal, though, is to try to have consistency. We don't want to have temporary board procedures for the ZBA and then different procedures for the planning board. So it's a bit of a Herculean task because we're under limited time frame. So we're trying to get everyone on the same page with the same procedures as quickly as possible.
Okay, so the original temporary board procedures that were signed off on by the chair and legal counsel and staff basically outlined the procedures for the board to operate virtually, like I said, via Zoom, and allowed public comment via email to a city info email address 1 week prior to the meeting up until the day of the meeting. And then potentially, if the board felt like leaving the record open for the project, the public would also be able to email post the meeting up to 1 week post the meeting. But like I said, the public had some input regarding that, didn't feel like participation was enough. Board members had some input, and the applicants also wanted to amend these procedures. So we have a draft here in front of you, which now allows additional participation, still allowing the public to email the city any comments, but adding live web commenting. So similarly to the way that we are in Zoom right now as participants, the public would be sent a link which would be posted on the notice in the Press Republican, on our website, on Facebook. There would be a link to the Zoom meeting that the public could click on. They would be an attendee in the meeting, so they would be able to see and hear everything that's happening, but they wouldn't be able to speak. Essentially, they would be muted during the meeting process until the chairperson opened up the public hearing for an item. And if they wish to speak, there is a raise hand option in Zoom. They would click that raise hand option and basically be put into a queue, into a line, until they were called on by the moderator of Zoom, which we have Ethan here helping us out as the moderator on the back end. So he would unmute that person. They would have, probably 3 minutes to speak, depending on how long the board wants to allow that public comment period. And then they would again be made an attendee that would be muted. We do have some language in here that basically says once you've spoken, we're asking people to actually sign off of Zoom and then continue to watch the meeting via YouTube just to free up space. We do have room for 100 attendees at this point, so we don't think there's going to be an issue. But in case there is, we are asking people, once they've said their piece, to actually leave the Zoom meeting and then continue to watch the YouTube the video that's streaming live. So in addition to written comment, which I said, live web attendee comment, we're also allowing people to pre-record voice comments by leaving a voicemail on the planning board, community development office phone line, or the zoning board phone line, if it's pertaining to a zoning board applicant review. And then also we're going to provide a phone number for people to be able to call in if they don't have access to the internet. So a phone number would be provided, the person would be able to call in. It would be similar to the way that an attendee works. So they would basically be able to see everything and hear everything via that phone line. And we also have instructions for people to, be able to get support from Zoom on how to join the meeting, how to raise the hand, how to access that phone number. So there's a lot of guidance that Zoom offers for people to be able to access this technology.
Milena, can you please talk about the process that you envisioned in helping to put these together, about how somebody would register to speak?
So I think that's kind of an open conversation that we need to have. I think there have been some options thrown around. We could have a sign-up list that people need to sign up prior to the meeting if they wish to speak, or they could simply just click on that Zoom link, be an attendee at the meeting, and then click that raise hand option that's at the bottom of the screen, and then get put into that line as a queue. So I think that's kind of an open discussion, how you guys think that would work best.
I have a question about people who are using the telephone. How would, for instance, if I've got a petition before the planning board for a project I want to do on my house, how do I know when to call the planning board because my issue is being discussed?
So similarly to the way that we operate now, we ask applicants to come when the meeting starts at 6 o'clock, and you sit in the audience until you hear that your item is being called. So we would assume that if you were an applicant on our agenda, we would tell you call in at 6 o'clock. You will sit there until your item is called. So if it's item number 2, for 69 Brinkerhoff Street, they would hear that that's their agenda item, and then we could unmute them at that time, and they could be a participant in the conversation.
So Milena, if for some reason that applicant lost the line or was not in line anymore. In this scenario, I would think we would allow them to hold until the end of the agenda if for some reason, until we can get a hold of them. I know in other scenarios, the board has taken the position, like if someone isn't in attendance at the meeting, like an applicant, that we were tabling their application. That was the process. In this case, though, if someone, like, once again, lost the line, you know, maybe move them to the end and make sure they have a contact number that we can reach back out to them and see if we can get them on the line.
Oh, absolutely. And I mean, I've seen that at our meetings before too. If somebody's running late, we'll skip over their item and come back to them later. And I think that would be the same way we would operate here.
Would people who are calling in ever be confronted with a busy signal, or are there enough lines going in that they would automatically have access to the meeting?
I believe there are enough lines, but I might defer that to Ethan.
Originally on the subscription of Zoom we had earlier today, we were allowed up to 100 attendees. We have now upgraded to the business model, which I believe allows at a base level 300. So I don't believe the system should be strained to any degree, because at no point have we had more than 30, 40 people at a meeting. So there's plenty of room for that for the system to handle them.
Something that we may want to look at. Oh, and I just don't know the answer is when you call in to be placed in a queue to speak, I don't know how that intersects with the queue of the online speakers. And so I don't know if there's any visual that lets you know that there's somebody on the phone waiting and where they are relative to who else is in the queue on Zoom.
Are you speaking to me again, just to clarify?
Well, I don't know that you have to respond. I mean, if you know the answer, that's great. I guess I'm just making the point that we might want to understand how the phone call-in intersects with the web app in terms of creating a queue that's fair to people so they're not waiting on the phone for 3 hours.
In the testing that I've done, once again, we will double check and make sure it all works appropriately for the boards. What happens, it's a matter of order. So if someone is an attendee, they log in through their computer, they're an attendee. And if someone calls after that person logged in, they are then on that next list. That's how it would work.
Does a person calling in have to have the Zoom app on his or her phone? Because, for instance, certainly people who are not even remotely adept at dealing with apps, etc. I mean, I think of my mother who, you know, if she had to call in and participate on Zoom, it just wouldn't happen. She would be able to make a phone call and she could be on hold, but a phone call is all she would be able to do. So what's the technological savvy that's going to be required by people who are either trying to comment or who are trying to petition the board? What kind of level of expertise are they going to need?
We'll make sure to explore those settings, but once again, I believe they will need 2 specific numbers. They will not need an app. They will need a predetermined telephone number, and then of course the meeting ID, both of which will be, as Melena described earlier, published, you know, whether it's a city website, in the Press Republican, and any other outreach that we deem necessary. So it would be as simple as having a phone number and a meeting ID number. But we can further check into those settings.
So Ethan, to further clarify, say I wanted to call, you know, I don't have a smartphone and I wanted to call from my landline. How would I get into the queue to be able to speak if I don't have that raise hand option?
I believe your number would still appear into the function without clicking the raise here. But once again, we'll clarify all that, and that will be part of informational, something informational that we can provide to the public to help guide them depending on which method they want to attend or communicate during the meeting.
Loretta, it's basically calling a 1-800 number, and then it's an automated voice that says enter your meeting ID, and then it says you're in the meeting. So that's, I mean, essentially what someone would have to be able to do.
But to be
Okay,
able to,
I haven't tried doing it just by phone. I've always done it, so I didn't know how the phone option worked.
Right. No, and I just wanted to explain that it's like if anyone can call a 1-800 number, they can do this basically.
Different question. How will the written voicemail and email comments be shared with the board? Will you literally read those, Melina, or how will that work?
Shalice can speak to that because I believe she planned on reading those into the record during the public hearing for each agenda item they pertain to.
Any written comments that are received by the board, I will be reading to the record. Any voicemails we were planning on playing as well.
Are there any limitations on the length of those comments?
That's a good question. I think that's something we need to discuss. I mean, I think we need to set some standards the same way that we, have the 3-minute time limit to a speaking comment. I think we need to limit, the reading of any emails that are received. Otherwise, Shalice could be there for 6 hours reading a 40-page email, and we don't want that. So I think we do need to discuss that.
I think it's.
We have received some that would take me easily 10 minutes.
I think it is appropriate to definitely discuss that as a board, how we handle written comment and reading into the record. I think that they should be read into the record. With that said, is there an option not only to have like a size limit on it, but also is the public comment received something that could be scanned and placed on the city's website, similar to the application material?
Dean, is that something we'd want to do with the public comments we've received thus far?
I think it's a valid point to put some kind of reasonable limit on the length of the document if you're reading it in. It's ultimately up to the board as far as what they're going to want to allow. It just becomes unwieldy if we have, a 50-pager that you have to read verbatim. That seems overkill. As far as posting everything on the website, offhand doesn't pass the smell test just off the bat because those are comments to the board. But that's just my first reaction to it. I don't want to say one way or the other whether that's inappropriate. So I think another alternative, as you're mentioning it, would be we also, we want to be cognizant that we're not restricting someone's right to speak. And frankly, we want to encourage written comments because that's, the best way to get your message in writing, very specific to what you want to say without the stress of public speaking and also without any limitations of what you're going to say. But one scenario could also be that we have a kind of an assurance that every written comment is circulated to every board member. And then for those that are exceptionally long, perhaps a summary and then a reference to the board if they want to continue reading. That's kind of loose though. That's not a great procedure to say. So I think this is something, it's a good point that you're identifying it. I don't offhand know the solution, but that's why we have a few days to take that guidance and try to hopefully create that solution.
I think if we're getting written comments, then we're going to get those anyway, so we can read them and we need to hear them so we can get that information on our own that way, just like we're reading, everything that comes in our packet every month. I think the only thing that should be read in is maybe the voicemails if someone leaves a voicemail. I mean, what else is there that can't be disseminated to us in writing?
I can say at least what we did at the Town of Plattsburgh Zoning Board. For the zoning board, when we received written comments there, we did circulate them to the board members prior to the meeting, and they were not read into the record, but they were made a record.
I lost you, Shalice.
Yeah, I mean, I think that's, things that are in writing that we can all read on our own. That would save us time and we all can digest it and at least we understand it, but it doesn't necessarily need to be read into the record, but then it can be made part of the record.
Another concern I
Right,
have,
during the, I'm sorry, Loretta, just one thing I want to add, the number of comments that are received in support and the number of comments that are received against it would be stated for the record. So if we do not read them into the record, we would state how many we received or who they were received from. That is at least what we did at the town of Plattsburgh zoning.
Is there somewhat of a consensus amongst the board that we want to have some kind of process for the written submission of records, or is there more to discuss there?
I believe, I think there's more to discuss. I think, you know, when we meet in person, if you want to make a comment, every comment is heard. We don't discriminate at all in any way.
No, we do though. We have a time limitation.
So I guess what maybe I would suggest is that every written comment is read up unto whatever time limit we establish for the meeting. The rest of the written comment would then, the entire written comment is included in the record as a written document, but we would read the document up unto the time limit.
That makes
Maybe
sense.
Ashley's.
That sounds like a good idea.
Not what.
Yeah, because normally when we have a public hearing, if someone doesn't show up, can they submit a written statement and we have to read it? Or what's the, what do we do with that? Or do they just have to show up?
Dean, correct me if you have different guidance, but in the past, I believe the board has taken any written comment that was submitted on behalf of an application. Sometimes it was entered into record, you know what I mean? It was submitted to the secretary and entered into record, or in other cases it was read. I believe the board, you know, however the board chose to handle that.
Yeah, that's my understanding, and it was a little bit looser. I don't think it was necessarily codified to a formal process. It was, if it's a short letter, they try to read it in. If it was lengthy, they'd refer to it. At least there would be a reference and it would be built into the record, but not necessarily read every time. It was kind of a, we'll know it when we see it approach, as opposed to, you know, very spelled out.
So something.
Can I raise another concern about people who are using a telephone who do not have access to a computer, or who simply, you know, don't have internet or aren't computer literate, whatever. If I have a proposal that's before the board and it's an architectural drawing, there's no way for me to communicate and respond to the board's questions because I'm not there to see what you're talking about. If you're, you know, if I'm getting a variance for a setback, if I'm getting a variance for a driveway, whatever, how does the board communicate with a person on the telephone when our reference is an architectural drawing or photos? Because a person with a telephone doesn't know what we're seeing.
From my perspective, I think any applicant who has a project in front of the board is going to want to have that video conference ability. And if for some reason they don't have the technical capabilities or the access, then very likely you would see some leniency from the board to allow them to request an adjournment if they're not comfortable that they're being heard. I don't expect that to occur because you're going to have sophisticated applicants. And if you don't, it's probably a very straightforward project without all of, you know, consultants or architectural things. But point being, I would expect that there'd be some flexibility from the board if you had that random applicant that needed that additional time.
Okay, but also when we're doing discussions about, like if we're discussing the DRI, you know, we post visuals of what the proposed building is going to look like, for instance, and what the parking lots are going to look like. And if there are people who are using a telephone, they have no way of communicating with the board because they're not seeing what the board is seeing. So how do we address that?
They will be accessed. The meeting would be live streamed on YouTube. So presumably they would have some kind of ability to see it if that person this person we're describing just had no ability. Frankly, the requirements for public hearings don't require that level. They require that person to have a voice and an ability to be heard. So if they want to present their piece, it's not typically a back and forth where you're getting members of the public having a question and answer. That's frankly not the recommended best practice. They have a right to say their piece. Is it a written document? Sure. Is it a voicemail? Okay. Is it a telephone statement? Sure. Or is it a video conference? Sure. It's up to them, but it's really one-sided. Here's my opinion about the project. Take it or leave it.
So for instance, the downtown, the DRI, if I only have a television, or excuse me, a telephone, I do not own a computer. How do I know what the proposed project looks like? Is there a way for me to find out what the drawings are, what the specifics are before the meeting so that I can then call in and describe my concerns?
Loretta, all of our documents are online. And like you said, if this person doesn't have access to the internet, I mean, I'd assume if they were calling in, they've already seen the project, they understand the project, and they want to say something about the project. So they're pretty knowledgeable at that point. Nothing has changed since the February hearing where we had an open public meeting where the public was able to come to City Hall and say their piece. Nothing has changed with the project since then. But if they did want to see it, it's online. Unfortunately, we aren't in City Hall right now, so we don't have paper copies to give people. But those were available in City Hall up until last month. So I'd assume if they're calling in, they've already seen the project.
So for a project, for instance, that one of my neighbors wants to do, my next door neighbor is proposing a big renovation. How would I know what without a computer, how would I know the details of that project, especially if I didn't even know that they were planning to do it until I got a letter saying that there was going to be a planning board meeting about it. Now, how do I find out what my neighbor is proposing and then be able to describe my thoughts about it?
There's a notice that's published in the Press Republican with each agenda item's description. Similarly, same thing that you guys see in your agenda, that's posted in the Press Republican. So there's a description of each agenda item that they could read in the Press Republican.
I just want to clarify that, Melina, we don't publish the full description of the agenda items in the Press Republican.
I thought you did.
For public hearings, it explains that there's a public hearing and what a very general overview of the project is and where it's located. But the public notice requirements do not require a full description of every item.
Okay, so then I would say, I guess if they called in, we could do the best we could with, explaining the project, because typically we would have me do the overview of the project. We'd have the applicant go into further detail, then we'd have the board ask questions before we open the public hearing. So hopefully while they were listening on the phone, they'd be able to get a pretty good idea of what the project was all about before they were, having the option to answer or ask questions.
All right. And so is there a precedent for having boards make decisions this way with that kind of input?
During a pandemic, I would say we don't have a precedent for this. No, we're doing our best.
And I'm being a pain in the ass, but it's just something that it's a reality that worries me, because I am conscious of, I've got a lot of elderly people who live around me, and I don't know what kind of technical know-how they have. And for instance, if I was about to, do some major project that involved a, pretty substantial variance, how would they know the details of what that was going to look like so they could have an understanding of how it might impact them?
I mean, I suppose they could always submit a FOIL request. I don't know what our department or any other department's ability to adhere to FOIL requests are at this time.
It's a great question, Loretta, because I think all of the focus has been on the items that are on our current agenda and how we manage those, but you're asking questions about moving forward for new items and how people will learn about those and the typical outlets that somebody without internet might use, such as going to the public library and using their internet, are not available. And right, so you might know that a project is happening because you read about it in the paper, but you have no idea what that project looks like and what its impacts may be. Thanks for raising that point.
Yeah, I mean, I guess, like I said before, you know, we'll just have to do a really good job during our project review of describing these projects and going through them step by step and what they entail. And hopefully, if they're listening on the phone, if they have called in, they'll be able to get a pretty good idea of, you know, the project itself before, you know, the public hearing is open.
Perhaps not to make more work for you, Melina, but if someone was concerned about a project, if there was a way they could literally call in, I'm talking about before this meeting, and have some kind of narrative that they could listen to. If you want to hear about this project, listen. Want to hear about this project, listen. And it would be 16 sentences.
Melina and I are still working. You know, our phone numbers are going to our voicemail. If anybody wants to call in with any questions on any project, we can certainly try to provide whatever we can. I'm still going into City Hall on occasion. If I have to, I will mail out copies of documents to people. I don't, whatever is.
Yeah, absolutely.
Yeah, that's where I was going to go. That I don't know if it made it to the temporary rules, but maybe add a provision that if someone requires some kind of special accommodation, call this number, and then everyone's going to do their best.
That's a great thing to add to this. If anyone needs special accommodation, like Shalise said, we're still going into City Hall once in a while. If we need to make copies of something, if it's an architectural drawing, etc., we can do that and we can mail those out to people.
I think that's a good idea. And I think also, you know, as with our temporary measures, you know, that's something for the board to consider as they're hearing the public, as they're hearing the applicants. Is this something that we need to obtain more information, or we need to pass out more information before any kind of decision can be made? Does it have to wait until the next meeting before a decision can be made? You know, the board's got to consider that from one application to the next, but you know, it may take longer than normal.
You're muted, Loretta.
Can you hear me now?
I'm not clear on where we left the discussion regarding written input and how we're going to manage that.
Just to add to that, Reg, as well, I didn't get a chance to comment on that either. I want to make sure in our written comment, especially if we have projects that we receive quite a bit, that the board has a clear pathway to receive it and to understand that we received all of it. You know, at the moment, I know I've seen some that has come from staff. I've seen some all of a sudden that we're just random emails from different individuals. I don't know if it's in city record or it's just an email to us. So I really think we ought to clarify how that written record is received and then how it comes to members as the written record.
I mean, to your point, I've received some of those inputs and they've been 41 pages long.
Right, and I think we discussed earlier in the pre-meeting that anything that's coming directly to the board, if you want to respond to that person asking if they want to make that part of the public record and then give them the city info email address to email directly there. And then Shalise is actually compiling all of those public comments that are being received, and she will send those out to you the day of the meeting, because we are taking comments up until noon the day of the meeting. So after noon, she'll compile everything, send that all to you so you have that for the record. And then I believe we said we would read everything into the record for a period of 3 minutes, cut it off, and then, you know, everything else it's already there. You already have it.
I mean, I'm here to do whatever you guys decide to do. Go ahead, Reg. Sorry.
I'm sorry, Reg.
So the limitation will be a 3-minute read.
That's up to you guys.
I understand the earlier point that was made, but I mean, clearly, we're going to get additional inputs, and I think some of those are going to be quite lengthy. And I understand that, and I agree that we want to hear all of that information, but as a practical matter, I think we've got to know how we're going to manage that through the course of the meeting. And if we're setting a 3-minute limit, understanding that anything that is submitted will be put in the record, if that's the understanding, then I'm fine with that, but I want to make certain that's where we're at.
I'm a little concerned also with leaving it, you know, in our meeting here today, that individual board members are going to maybe receiving emails and giving directions to public or applicant. I mean, I just don't want to leave it that the public expects that you know, individual board member is somehow going to enter their stuff in the record. I really think that it has to be clear direction that, you know, here's where you submit it. When you here, this is where it will enter into the record, and it will get to the board, and it will be read out loud. If the board chooses 3 minutes worth, it'll be read out loud. It will be entered into the record.
I received an email, a lengthy email from someone, and I forwarded it to the entire board, and hopefully everyone got it. Because I didn't really know what else I was supposed to do with it. And I don't know if that's something that's now part of the public record. I don't know if that's going to be read. I immediately took myself out of the equation because I didn't think it was appropriate for me to be responding. But again, I don't know if that's something where we want to have some guidance for the situations when people do come to us personally via an email or whatever. Does that then become official, or is that just, you know, I'm just not sure what kind of guidance we want to have going forward.
I just want to point out one thing, guys. I have not released any of your emails to the public. Your emails are personal email addresses. So if you're receiving personal emails from the public, it's something either that you've already given out, or it's somebody that's contacting you personally that you have a relationship with. So if that is something you're receiving, I would verify with that person if it's something that they want shared first, because it's not something that has been given out as by the city as a way to contact the members. The other thing I did want to add, sorry, before, I know Melina mentioned something about we were receiving the comments up until noon on the day of the meeting. I would recommend, if we are receiving this many comments, maybe we should move, and it's up to you guys, but if you guys are open to it, I think it should probably be moved back at least a couple of days so you guys have time to review those comments before the meeting.
I'm sorry, you broke up. I didn't hear the tail end of what you were saying.
Right now the document does have the meeting, any written comments being received up until noon on the day of the meeting. If you guys, this is up to you, it's your decision. But if whatever you guys want to do, I think maybe that should be moved back a couple of days to allow you guys time to review and read those comments from the public. The other side of that is we don't want to make it too early so that the public doesn't have enough time to comment. So again, it's up to you.
Melina, do you have a sort of summary recommendation after hearing this? And, you know,
yeah, I'm trying to think through it. I think Shalise is right. If we're getting a lot of lengthy emails that are upwards of 40 pages and we're not going to be able to read those into the record because we only are limiting it to 3 minutes, then I think it makes sense to move that date back to maybe a day or two before. That way you guys can fully read all of those comments, digest them, and then at the meeting, you'll already, you know, have read them, and then it's just basically a formality of reading those into the record. I think that makes sense. And at this point, it's the 7th of April. Our next meeting is until the 27th. So people do have quite a bit of time here. If we release these temp board procedures at the end of this week, that gives people at least 2 weeks to be able to comment if we ended a few days before the 27th.
and in addition, the public would have the opportunity to sign up or join in on the meeting the day of.
Absolutely.
I really, again, want to also make sure we have a clear method of receipt of comments, that it's somehow advertised that this is where comments are to be submitted. and that, all board members are, well, the best we can, all board members are receiving a complete packet of those comments directly from staff. So we know that we've seen the complete record. Anything else?
Do you want to receive a complete packet of comments, or do you want to receive them piecemeal as they come in?
I have a,
Packet, please, packet, not piecemeal, please.
I was to say, I honestly have a very hard time seeing all these piecemeal comments, especially when I have emails. I get email from staff, and then I get email from individuals that somehow got my email. I mean, it is very difficult for me to follow it all.
So Shalice, what would make you comfortable as far as a time frame? Say our meeting is, the 27th. If we stop public comment, maybe I don't have my calendar in front of me. Let me see here.
I'm comfortable with whatever. Whenever the board feels is a sufficient amount of time for them to receive the comments, whatever they need. If they feel they need 3 days to review all the comments, push it to Friday, and I will get them the comments on Friday. If it's Saturday, I'll come in on Saturday. I'll put the comments together. Whatever you guys need.
I like the Friday noon idea.
Which would be the 24th. So
Yes.
stop
Yeah.
comments, stop accepting comments Friday the 24th at noon. Shalice could compile all of those into one document and then disseminate to all the board members for review over the weekend, before the Monday, the 27th meeting.
I would agree with that.
I agree with that.
I like that idea as well.
I agree that 12 noon on Friday is the right time for Shalice to compile them and get to us, though I don't know, because we're leaving the record open for a week after the meeting anyway, why we would stop receiving comments up until, so I would think that maybe comments that we receive after noon on Friday could still be read for 3 minutes. They're just not in the packet that we receive.
I don't know what to say. I'm
I
sorry.
think I think that circumstance arises only if the board decides not to vote on it during that meeting. Right? Do we have that? Can we scroll down to the section on post? Holding the record open. Yeah. Okay.
And actually, Dean, that whole 7 day after the record was in the old version. It's up to the board, but I'd say you keep the written ability to the next, to the 3 days prior to the next board meeting. Keep it consistent.
Say that again. I didn't understand that. Can you say that again? You're saying if you hold the record open.
If you hold the record open, keep it consistent. We're gonna 3 days before 3 days before any scheduled board meeting under these circumstances, your written record is due. If the board hasn't made a decision on an application, we'll accept written record up to 3 days before the board
So
meeting.
if we keep it open, then we just do the same thing for the next meeting and we only take it to the 3 days prior. And if we vote on it, we take no more written comments.
Right, because I think holding the record open means you've already closed the public hearing at that point. So the next meeting would mean there would be no public hearing anymore. You'd read those comments you had received up to that point, and then you guys could vote.
Just to make, I guess, a general point, at some point you do need to kind of cut off just the ongoing nature of the public hearings. So I agree, we want as much participation as possible, but it can't be forever.
I would agree, Dean. I just want to make sure and try and keep things consistent in terms of timeframes. If we say written record and our public hearing is open, we accept written record up to 3 days before the meeting, the actual physical meeting. We have open public comment in that meeting, and then the board decides to close. One of the benefits we give to the public is that we leave it that the board considers leaving it that the public can submit written comment up until 3 days prior to the next board meeting. Keeps it consistent, gives it a little more open time for the public to comment as well. With that,
Can I bring up something else? Just a typo. that we need to fix? Top of page 2, first paragraph. There's wording here that says those times shall be set by the board. So it either needs to be those times or those time limits shall be set by the board, but the sentence doesn't make.
Okay. Noted. So is everybody more comfortable with these temp board procedures? Obviously, we have some cleanup to do, and we'll add some more language in regards to the timeframes for keeping the record open and written comment. But is everybody more comfortable now that there's more options for participation? So now we have written comment, pre-recorded voice comments, live telephone commenting, and then also the live web commenting. Do we feel more comfortable now with the board procedures moving forward for the April 27th meeting?
I do.
Sorry, I actually still have one more question. I don't know if this is the dean question or if this is a preference of the board question. For all these different methods of communication, how are we going to handle people wanting to comment more than once? Because currently during a public hearing, when people hit their 3-minute limit, we don't let them return for more public comment. So if somebody wants to submit a written comment and a voicemail and attend the Zoom conference, what are we doing?
I believe in the last public hearing at the February meeting, we did have people that commented more than once.
That was on separate actions. That was on the subdivision, on the PUD, and on the site plan. So it was
Thank you for
not
the
more than
clarification.
once on each action.
Thank you for the clarification, Shalise.
That's a good point. I don't have an answer off the top of my head. I think if the board recognizes that would just create some superfluous waste of time if someone's saying it, writing it down, and then giving a video on it. Perhaps we can add some language, at least aspirational, but maybe a little stronger, saying if the board determines that this is a repetitive comment, then we will note it and move on.
I would just make the clarification, Dean, that repetitive comment isn't good enough. It's okay if 10 people want to get up and say the same thing, they have a right to do that. So it needs to contain language.
I'm saying from the same speaker. Yeah, from the same speaker.
From the same speaker.
So what I'm hearing then is ultimately we would try to ask out of consideration that, an individual picks their medium, whether it's written or video or, calling in. That's their method of communicating.
I would think, Jim, that all of those would still be included in the record because we don't have a way to filter them out of the record, but I guess this falls to Shalise, would do her best to make sure that what is read into the record or heard is only once from an individual, but all of them would be included in the record.
Yeah, right now, if anybody provides any written testimony, that gets included in the record. So that would be separate. But I'm in terms of a public hearing and how many times they're allowed to speak or comment on something, I guess that's what my question is.
I mean, people can write a letter now, but prior to coronavirus, you could write a written comment to the board and you could show up and speak at a public meeting. So I don't know, this is a sticky wicket too.
Yeah, there's no question that the board in the past has received written comment and has had an individual come to the meeting. Usually the individual was taking the written comment though and reading it or paraphrasing it and then handing it in as part of the record. So, I think if someone ends in written comment, and once again, if they want the,
I can say from experience looking at what we receive, what I'm mostly seeing when people provide written documentation is some sort of supporting documentation. Coming to mind is a certain retaining wall where pictures were provided by neighbors. That's usually what I see in terms of supplemental documentation. Lists of businesses or recent ones, some other things like that, but I don't usually see them providing the same comment in written form as to what they're saying when they're before you guys.
Another question. Can comments be made regardless of the medium only by individuals, or can they be made by groups?
There's no prohibition on a representative of a group speaking. I mean, you'll frequently see a nonprofit or a certain coalition that's going to make comments on behalf of the group.
Okay, great. Thank you.
Okay, if we, I guess if we don't have any more comments or discussion from the board, Milena and Shalice, are you generally, I guess, clear based on our discussion, the direction?
Yes. Since the zoning board meeting is April 20th, we're hoping to have these board procedures finalized by this Friday. So we'll try and make the edits tomorrow and get these out to the whole board by tomorrow for review.
So I don't know what the process from here is, Milena, and that if these need a motion and then a vote by the board. Can you clarify how we adopt these procedures?
I'm going to defer that to Dean at this point, because the last temporary board procedures we had the chairperson sign off and then legal staff sign off on them as the representative of the board. I don't think at this point it's necessary to make a motion, but Dean can clarify.
Yeah, so the technique we used last night with the ZBA at least was for the board to have a general consensus or part of the discussion to reach some kind of general consensus, which I think we've done, or some direction, and then designate the chair and or anyone else the chair wants to kind of serve as the liaison between city staff and the board, so that we would trust that the chair would then be the representative of the board. Staff will provide the finalized documentation to the chair. He or she will then circulate it amongst the board however he sees fit and discuss it, try to build that consensus, and then respond back, yep, we're all on the same page, and then approve it as the temporary board procedures.
And well, I guess I have two comments. I mean, I think a vote by the board sends a stronger signal.
Well, you could, I mean, if you want to vote, you could resolve to designate your chair as your representative, but he is your chair, and he's your leader here.
Right. I mean, it gives a stronger signal. At the same time, I think consensus is important. I don't know. I guess I want to hear some other voices on this. Do we want to be a vote as an alternate member? I don't get to vote on this anyway. But it sends a stronger signal to have a vote behind this.
So Dean, let me I guess ask a question back to you in regards to these temporary measures. I know we're trying to set a level of consistency, but the original temporary measures that I and the zoning chairman reviewed, we envision those just that as temporary measures to outline to the board a process to allow us to continue moving. Same thing with calling the special meeting. At that point, calling the special meeting was allowed under the ordinance by the chair. We could not get a quorum of the board together, seeing that we can't take straw polls and we're not supposed to be together to actually meeting. We had to have something in place. And I was expecting that this kind of conversation would occur. I was hoping that this kind of a conversation would occur and that the board could make decisions accordingly. With that said, moving forward, I did see that the zoning board had selected their chair and co-chair sort of as liaisons to the board for the next meeting and to work through this process. I don't have any problem with that if that's what the board chooses. With that said, I just want to be clear on our rules. In the past, we have talked that, straw polls or email polls in the background were not something we should do. So I just want to be clear, I have no problem if the board designates myself and another person to sort of work with staff on this. And I'd even, talk to members individually or something. I just want to be clear that I just want to make sure that we shouldn't be taking votes or making decisions on things in the background via email that aren't in a public meeting.
Yeah, and that's a really good point, and that's what I was anticipating. You articulated it better than I did, which would be you would then relay that one-on-one to your board individually, see if you can get a consensus, and you use your discretion. You may not get 100% a unanimous decision, but if you get a consensus, that's what we can do at this point. I don't want to see a scenario where we sit on this for 30 days or till the next board meeting, and then decide these are procedures, and then we have, another month of public hearing. It just keeps going, and at some point we have to adopt these as temporary, because they are temporary. It's not permanent. It's during the length of this emergency.
Okay, so if the board is comfortable with that, and if you have any other questions, surely throw them out there. But if the board is comfortable with that, I'm comfortable with taking this, working with staff, and reaching out individually to each person and walking through it. Make sure everybody, make sure there is some consensus before the next board meeting.
Well, and I think based on everything we've discussed here today, we do have a pretty good consensus. Maybe there's a few things that we just need to clarify, but that was the whole reason of bringing this up while we're in a public meeting. So there shouldn't be a ton of things that are controversial in this document to try to figure out to get in place with the situation we've been given.
I would hope that. I would hope.
So consensus to me means that everybody agrees not to stand in the way. And I would agree to that. I won't stand in the way of moving these forward.
And again, these are temporary board measures, as everybody recognizes. This does not stop, a board member from voicing their questions, concerns, or anything in the future on what it.
No, and I appreciate the discussion on them and the way we've gone about it. And I appreciate the revision of the original document to where we are now. I think it's much stronger. And so yeah.
Okay, if we're
Can I just add one thing, Jim?
Sure.
And I don't want this to be, any issue that throws it off, but you are our chair and I highly respect you for that. But you also are recusing yourself from voting on our only controversial issues. So might we not be wise to have the vice chair and you represent the board? I just don't want you to be criticized for taking a position that might be adversary.
No, I appreciate that. No, thank you, Rick. I think that's the idea of having a second person involved with it. Once again, I have no problem still going ahead and looking at these temporary board procedures as the chair, and having a second person as well there. And then, we can individually confirm with members that there's some consensus.
Yeah, I would agree with that.
I'm going to decline to be part of this, and I'm going to suggest that Derek be your second man. Okay, I'm just going to decline to be part of this discussion.
Thank you, Marissa.
You got to understand, I am just going crazy right now, even though there's extensions in place and everything, and I am paying pretty much as little attention to this as possible. I hate to say that.
And thank you for that. Yeah, and that's, Derek, that's, it's up to the board.
I think Derek would be an excellent choice.
Works for
I
me.
agree.
Works for
I'm
me.
in agreement.
Okay, sounds good.
Okay, well, thank you all then. I guess we move on from item C of other business to the item D, monthly project review. know, there has been discussion about this, and I think, Milena, maybe you can pick up and summarize as a whole first, and then we address each individual planning board item.
Sure. So as you know, tonight was supposed to be a public hearing for all of the agenda items. But due to the fact that we're amending our temporary board procedures, I don't think that we can actually open the public hearing for these items. I think we want to wait until our new amended board procedures are in place and finalized, and then have the public hearing for these items. So it's, a recommendation that we table all of these items until April 27th after our procedures have been finalized.
I'll make that motion.
So real quickly, so at this point, that gives a good general overview. I think similar to the zoning board last night, we should make sure that this has gone down through each individual application and a roll call is actually established of the board for each individual application item. I would start off with, just to summarize a little bit, I would start off with planning board application number 2020-
Jim, for the sake of efficiency, you could also do, I agree we need to spell out each specific item, but you could do a merged resolution because for the sake of timing, saying you'd entertain a motion to table items X, Y, Z, spell it each one, but do it as one combined resolution as opposed to each individual.
So I'm going to say this real quickly, that, item number 1, I would say that is a standalone resolution. The other items are resolutions. If the board so chooses, they can handle those how they'd like, but I'm a recusal from that item or from the rest of those items. I don't know if anybody else has to recuse themselves, but I do. So if we can start off with item number 1, decide on what we want to do, and then whatever we want to do for the remaining items, that's up to the board and the chair at that time. So
I have no agenda in front of me, so keep talking and I will grab something from the back.
So planning board item 2020-01, this is 5057 South Catherine Street. I think that most everybody has seen the project description in regards to a 12-unit, 6,100 square foot multifamily dwelling structure. Needed variances. I guess we have recommendation of staff in regards to tabling this application at the time. Do I have a discussion or motion from the board?
I make a motion to table item number 1 until April 27th meeting.
I second.
Sorry, point of order. Is Loretta is the alternate on this, correct? Has there been any action on
Never mind.
57 South Catherine Street?
Actually, in this case, we Loretta would still be an alternate because we don't have any recusals from that.
Correct. So I'm an alternate. I don't vote on this one.
Wait, no.
I'll second it then.
Okay, so I have a motion by Derek and a second by Rick.
Okay. Roll call. Jim. Oh, wait. How are we doing the chat vote tonight?
I think a roll call is fine for tonight.
Jim Abdullah,
Yes.
Marissa Gilbert,
Yes.
Derek Rosenbaum,
Yes.
Richard Perry,
Yes.
Reg Carter.
Yes.
Motion carries.
Okay, thank you. Again, moving on to items 2, 3, 4, 5, and 6. I hand those over to our coach, Marissa, and I have to recuse myself from those for direct or indirect involvement with the applications with my firm AEDA.
So I'd like to entertain a motion to table applications number 2, 2019-09, 61 Beekman, number 3, 2020-02, 52 US Oval, number 4, 2019-24, 22 Durkee, 2019-11, 22 Durkee, and 2019-10, 22 Durkee to our next meeting.
So
I will make that.
I do have some questions about those. I'm not sure if those questions need to be addressed before or after the motion is seconded.
I don't know either. What kind of questions are they if all we're doing is tabling?
Well, I mean, there are questions that I think need to be answered before moving on. So one of those questions is that I am curious about. From up until this point, I think that Dean has done an admirable job as counsel to the planning board. But at this point, when we are talking about items in which the city is the applicant and Dean represents the city, I am unsure if the planning board has legal representation. And when we're talking about these issues, I believe that we have a right to legal representation, and I want to clarify Dean's role.
I really understand that question and I agree with you, but I'm not sure it's going to get clarified or fixed tonight, but it certainly could be addressed before the next meeting.
Well, this is our only chance to hear that before the next meeting because we can't convene a meeting of all of us prior to that.
Dean, what do you say?
It's a big question, and I've seen the comments put out this week attacking my role. So I do have a lot to say about it. I personally don't think it's appropriate for this actual agenda item to table the motion. So I can give you a summary of my opinion, or I could provide a written memo to the board, whatever is appropriate, or whatever you prefer rather. But for just purely procedure, this was just a motion to table these items. I think it appropriate to get through that motion first, and then you can discuss on how you want to discuss my role. Or if you want me to hash it out now, I'm happy to. But this is a very technical procedural motion in front of you, just to table items. Was seemingly non-controversial because there's no ability to act on them.
Once we have tabled the items, are we able to open the meeting up to talk about that? Or once we have tabled the items, are those items tabled and we can't talk about them at that point? I'm happy to wait until the item is tabled, Dean, but I need a kind of clarification on Robert's rules.
I'm not positive, but as far as I'm aware, you guys are still a convened board and you can bring new business at this point.
Yeah, that's as Shalise just said. I think you'd get through these items and then you can request from the chair that we can discuss my role.
Okay, so do I have a second? I don't think I had a second.
I'll second.
Roll call. Marissa Gilbert,
Agree, yes.
Derek Rosenbaum,
Yes.
Richard Perry,
Yes.
Reg Carter,
Yes,
Loretta Rietzma. Do I go to Loretta or do I go to Kurt?
We don't know. We never decided.
Loretta sat on most of these items when actions were taken, so I think Loretta is our standing board member.
Elaine, I would disagree. I think this is a decision for the chair. I sat on all of the Durkee items for several months, including when the first action was taken, which was to call a special meeting of the board to discuss the draft generic environmental impact statement.
I think
Loretta
Marissa is
sat
the
for
chair on this one.
I have a coin, okay? I have a coin. I'm gonna flip the coin. We're gonna figure it out. Kurt,
Wait,
you
heads of two.
yeah, well, I'm gonna flip it. Kurt, you get to call, okay?
Oh, I'll call tails. Okay. Thank you.
Loretta, were you at the
Yes.
motion carries?
So discussion of new items? And I wonder at this point, do I stop being the chair? Because
I believe, yes, I believe.
I don't know.
So I have two questions.
Hold on, real quickly. I hear discussion about switching chairs. I believe that the new business items that maybe Kurt wants to discuss are in the realm of applications I'm recused on. So I really feel it's appropriate for this discussion that I'm still in recusal.
Okay. So I'm still chair.
So my first question I asked, and Dean can address in just a second, and I'll just ask my second question now so that maybe Milena can just prepare for a second. Milena has clarified this question for me, but I think it's an important one to hear as a board, and that is that the Common Council adopted a resolution a couple of weeks ago that has caused some confusion. And the resolution is giving the mayor the right to enter into an agreement with the county to waive the necessity for some county planning board review or something like that. I'm not exactly sure. And I would like to hear a clarification of what that resolution was about and how it will be implemented and if it is retroactive. So maybe we could hear from Dean first and give Milena a chance to.
Okay, so I'll take your second question first, actually, because I was involved with that. That's under the General Municipal Law 2239. There's a provision where municipalities can enter into an agreement with the with the respective county planning board, predetermining that certain actions are of such minor local nature that they don't require the review by the county planning board. So it's nothing specific to any project that's in front of the city or the county. It was just a waiver form that they've developed. I can't recall exactly offhand all of the items, but it's basically small minor variances that are presumably and understandably not a countywide concern. So there's an ability pursuant to general municipal law to enter into that contract that says for these specific types of items, again, Milena can summarize if she has it handy. I don't have it handy. But again, very minor type items don't require county review.
And Dean, are there criteria or some threshold that dictates when they do or don't get that review?
So she just put it up on the screen right now, and that's the list of them. Yep.
Okay, very cool. And clarify whether or not it's retroactive.
No. So this is any projects going forward, and typically this would be referrals from the zoning board, not really the planning board, because those have a bigger, I guess, impact on the countywide decisions. This is simple things like side yard area variances for single family residential uses, rear yard area variances, temporary special permits for residential occupation of a mobile home, and then site plan review procedures, which would be the planning board referrals where no physical exterior change to the property is happening. So this isn't stuff that happens very often, but sometimes, administration of making sure we're sending everything to the county gets a little burdensome. So these are just, like Dean said, these are things that the county has decided would not have a countywide impact. They don't need to review them, so we wouldn't have to refer them. And I guess the county has this in place with multiple municipalities. This isn't special to the city. Glenn was actually surprised that the city didn't have this in place.
Thank you for clarifying that, Milena and Dean.
Okay, so now.
Can we assume one thing that none of the projects before us fall into this category?
No. Every project that's in front of you now has been referred to the county that required it.
Okay, that's what I thought.
Okay, so turning to my role as planning board counsel, I've seen some of the most recent comments that came out that were submitted. attacking my position. I'll put aside my misgivings because it's frankly attacking my my ability to be an attorney. So I'll try to put that aside the best I can to keep emotions out of it, because that's my role. But I do go back to the charter. So the first, or to summarize that allegation, it's my understanding that it's that my allegiance is to the Common Council and not to this board. So I go back to the charter, and just to clarify, section C5 4.2b spells out the powers and duties of the Corporation Council, and specifically says that the Corporation Council shall serve as the chief legal advisor to the mayor, the Common Council, and all city departments, offices, and boards, and shall represent the city in all legal proceedings, and shall perform any other duties prescribed by law, charter, or the ordinance. So very clearly spelled out in the charter, my role is to the Common Council, to the mayor, to the department heads, and to each of these respective boards. So that's spelled out. It's in the legal arena, we call it an organizational client. So similar to a corporation with different divisions, I'm in-house counsel to the city as a whole. My duty is to the city as a whole, not to any specific individual or any specific board, but to act in the best interests of the city. As a just historical perspective, my predecessor, John Clute, had a similar role with the city as corporation counsel, where he represented the Common Council, the mayor, the respective boards, and the department heads. Looking back, actually, just coincidentally to this PUD project, I saw some notes where John Clute actually was serving as planning board attorney and zoning board attorney during the review of the PUD that came before those boards in 04 through 06. Second part of the analysis is alleging, conflict of interest. So that means something. It's not just a term that's thrown around, and it may be thrown around loosely, but it's something that's really personal, and I don't call it upsetting, but I treat it as an attack. So if someone says that I have a conflict of interest, it triggers, my review of the New York Rules of Professional Conduct, which describe what a conflict of interest is. And in that regard, Rule 1.7 describes a situation where a lawyer may have a conflict if they are representing a client with differing interests or a significant risk that my professional judgment on behalf of a client is adversely affected by my own financial, business, property, or other personal interests. And that's the key point of it. First off, is there a breakdown between the Common Council interests and the planning board interests and the zoning board interests? There may be different review or interpretations or takeaways, but in my role as representing those respective boards, my interests are very much aligned. It's to protect the city's legal liability and to make sure that, to the best we can, even in these crazy circumstances with the COVID virus, just as an example, that we have a consistent and a fair process. The second part of a conflict of interest is if there is some risk that my personal judgment, my professional judgment, is going to be affected by my personal interest. So again, I don't have a personal interest in any of these projects. I'm not a member of Prime. I'm not a member of any organization that's going to financially benefit. And I can use an example here that's helpful. Several months ago, I purchased a building. I had to come in front of this board for my own personal law office for some site plan review. And in that case, I had absolutely no involvement because in that case, I had a very personal interest in the outcome of that board's decision. In this case, again, the city's goals are aligned, which is to protect the city's legal interests. I did review some ethics opinions. There are some situations where the New York State Bar has opined that an attorney for the board could not represent a private party in front of the board. And that makes sense, an emphasis on the word private. So again, I couldn't have a client that wanted a variance or a site plan review come in front of this board and then come and sit down behind the table to give you advice about the review of that project. So we don't have a private client here. We have the city as applicant, but again, it's not a private client. Another point is that I'm not, even though we have the city as applicant, I'm not the one who is representing the application. We have city staff, we have consultants, we also have the applicants. They have their expert review. Everyone that I just described is the one that's literally standing in front of the board and making that advice or making that advocacy or role. We also have special counsel. So there were some comments made by the public that this board has the ability to seek side counsel or expert review. For these Durkee projects, we have utilized the services of LeBairs to do a technical review, but we also have special counsel, that's Miller Mannix. Mark Schachner was brought in specifically to deal with the complex GEIS review, because that's something that required a level of specialty that I personally didn't feel comfortable with, because he had that experience with the GEIS. So we have availed ourselves of that expert review when required. Another part of the analysis, going back to the kind of the heavy-handed or the impactful allegation of a conflict of interest, is to go to Article 18 of the General Municipal Law, and that again spells out where a municipal employee would have a conflict of interest under the General Municipal Law. And again, that deals with situations where someone has an ability to approve or disapprove a contract or audit bills or appoint officers, something with real discretionary power. Again, my role is to give advice about options or protect legal liabilities, but I'm not signing contracts or anything like that. There are comptroller opinions that have confirmed that applications to planning boards or ZBAs are not contracts under the General Municipal Law. It's not a purchase order, it's an application. I would, if there are legal questions, I would hope that they are asked, and I hope that if they are asked, I've answered them. I can't think of a scenario where it could be fair to say that I've misrepresented something or advocated. The example that comes up when we had the seeker lead agency dispute, I laid out the options that the council has the power. They've requested to be lead agent. The planning board could seek that status. The zoning board could seek that status. And if you want my opinion, I'll give it to you, but those are the legal options. And if you want my personal opinion, that's fine. So I saw that attack as well. It's insulting. And I'm trying to keep that separate. So I stand before you. I'm available to answer questions. If you have a question, I hope I've answered it. And my goal again is to represent the city as a whole. It's certainly, there's examples where a municipality will have a planning board attorney or a town board attorney or zoning board attorney. In this case, for the city of Plattsburgh, for at least the past 20 years, possibly longer, there's been one corporation counsel that represents all the boards. So there are other examples out there, but that's not a mandatory requirement. Again, I don't have a personal or financial stake in the success of any of these projects. I've always done my best, and I before a few days ago, I had pride in the fact that I was trying to represent the city's interest as a whole. So if there's a vote of no confidence, that's important, and I would take that to heart and do my best to try to find other representation. And at that point, that would trigger a need for the council likely to basically allocate funds to this board. And also certainly if there was some future event which caused there to be really differing interest, I can't think of a specific example, but if for some reason the zoning board or planning board needed to sue the mayor, department head, the common council, that would obviously trigger the need for me to do that own self-analysis to say, obviously I can't represent one party in litigation against the other party. So from my perspective, there has been no triggering event. I hope my track record speaks for itself, but if there's a lack of faith, then that's not my call. That's something I would have to deal with and then address that accordingly.
Hey, Dean, can I ask you one question?
Yep.
My point in asking about the planning board's representation, in the unlikely case the city were aggrieved by a planning board determination and the city wanted to file an Article 78, what would happen in that case?
That's the example that I described. It's rare to see, but if that did arise, that would be the conflict. I'd probably step out of both roles. I don't, offhand, I don't know. I certainly wouldn't represent the planning board in a suit against a city and then defend it. That would be obviously inappropriate. So yes, that would trigger a change in analysis, because that would be a true conflict.
Okay, because that was the point of my question. And in case the city wanted to have a decision overturned that the planning board had made, obviously it would be a judicial appeal, and that judicial appeal would require legal counsel for both parties.
Yeah, 100%.
So it confused me as to, where do we stand in that role?
And that's so this conflict of analysis, that's why I don't take that allegation lightly. It's something that I continually do in my practice. And there are ways around it. You can have a scenario where you represent two parties or two co-defendants, and I've done that in certain circumstances, but you get the client's informed written consent and you can work through it. There are some conflicts that are insurmountable though, such as one party suing another party, which you could not get around. So it is something that any attorney should continually analyze and make sure that they are on the right setting. In this case, with an organizational client, it's I'm trying to walk that line, but that's not my, I'm subjective, obviously.
Yeah, I appreciate your response to the question. And it makes total sense. It'll be a decision that has to be made later on if the city chooses to sue the planning board.
Thank you for explaining, Dean.
So are we now at the end of the agenda, Melina? Is there anything else?
There is nothing else on the agenda.
One more? Oh, I'm sorry.
Oh, come on, Kurt.
I don't
My
recall.
dinner's been sitting here for 3 hours, Kurt.
I'm so hungry.
I don't recall if the planning board on the engineering plans of Durkee, on the stormwater plan, on the lighting plan, on the parking, if we have sought third-party engineering review.
We did, yes. We contracted with LaBerge. Actually, the applicant requested it. So we have received an initial review letter from LaBerge and response from the applicant, which I will get to you guys prior to the 427 meeting.
Okay, so we haven't seen that yet.
You have not seen it yet. We just had it
Got
completed.
it.
Yep.
Okay,
We will get it to you
very
though
cool.
before a vote is taken.
Yes, I had forgotten if we had done it and I thought that I hadn't seen it, but okay. Thank you for clarifying.
Sure.
Okay, I'd like to close the meeting if possible. Can I take a motion that we're ready to go home and shut this down?
Make a motion to adjourn the meeting.
Is there a second?
Second,
Was that Rick?
yeah.
It was
second.
Reg.
Okay.
Reg.
Okay. Wait, I'm sorry. Was it Rick or Reg?
Reg.
Let's, Rick,
Thank you. All right. Derek Rosenbaum,
Yes.
Richard Perry,
Yes.
Reg Carter,
yes.
Jim Abdallah,
Yes.
Marissa Gilbert.
Yes.
Meeting adjourned.
Okay, we'll be in touch.
Bye-bye,
Thank you,
Everybody.
everyone.
Thank you.